Hello. 1 2 3 4 5. Hello. 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 Hello.
हेलो हेलो हेलो
Hello.
हेलो 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 कैसे अपना ऑन करते थोड़ा सा दीजिए हेलो 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 तो ऐसे बोले पड़ रहा है लगाना पड़ेगा ठीक है खाली लास्ट वाला है ना सर उसको नहीं छूना है बाकी हेलो हेलो
Hello.
इसको या इसको
Hello. Hello.
इसी में लोगे में लास्ट वाला इसको से तो आपको मतलब नहीं
Hello. Hello.
हेलो पाँच जो करते थे करिए
1 2 3 4 5 6.
हेलो हेलो किसको ठीक है ठीक है ठीक है हेलो हेलो इसको इधर रखिए राइट साइड अरे जी इसको इस साइड रख दीजिए ना माइक को माइक को यहाँ रख दीजिए तो हमको काम करने में ठीक रहेगा काम मेन काम ही खत्म हो जाएगा
माइक ऑफ कर दें।
ऑफ रहेगा हेलो माइक चेक देखो आवाज अब ठीक है को हम नहीं कैसे कर पाएंगे? आप बोले हैं कि छूने के लिए नहीं हम
जज साहब आएंगे ना,
हाँ
तो इसको वीडियो ऑन कर लेना है
हाँ।
और इसको मिनिमाइज कर देना है।
आप रहिए।
अब हम यहीं पे हैं और उसके बाद कारोबार अपना चालू हो जाएगा।
हाँ।
कुछ नहीं करना।
बार बार उसमें बोले हैं कि हमको खुद ही बोले हैं कि नहीं जाने
हाँ,
के
इसमें
लिए।
कुछ नहीं करना है।
हाँ
अपना केवल वीडियो रहेगा सर का, ऑन वीडियो ऑन रहेगा।
मेरा वीडियो ऑन है।
हाँ, अब मिनिमाइज हो जाएगा। जैसे सर प्रॉपर काम करते थे पहले वैसे करेंगे।
आप रहिए।
हम हैं नहीं तो अभी मना किए थे ना वो।
हेलो हेलो चेक हेलो।
बार बार इसमें हम जाएंगे एक बार।
नहीं सर, आपको नहीं जाना।
ठीक है
ठीक है।
हेलो 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 माइक चेक। हेलो माइक चेक।
कैमरा ऑन रहेगा ताकि उनका फोटो जाएगा। बाकी फिजिकल ये नहीं खाली वो प्रोसेस है, कम्युनिकेशन चलेगा, कैमरा ऑन रहेगा क्योंकि आपको दिखाना है।
मैंने केस कॉल करके हमको कैमरा ऑन ऑफ नहीं
कुछ नहीं करना है, एक बार हो गया तो चलते रहेगा प्रोसेस।
उसी जीवन से गई
किसका?
इसकी बात
ना केस ऑन करके फिर क्या हाल
नहीं नहीं
ना।
When did you when did you send your slip? Yesterday? You have mentioned today? Then we
and certified to be the post of Mukhya Blood is going to take place on the 26th.
let him take oath, you can file election petition. Why you have to come here? Your matter will be taken up tomorrow.
Any violation of law will
Maybe we will see it tomorrow. Rejected. You can send your slip. Sorry, sir.
Actually, there is and there are several violations of law points.
Mr. Counsel, we made it clear that you should have sent your slip through email to the court. You have not done that. You want the.
I have done lot today.
Then your slip will be taken up tomorrow.
And not just 10 minutes before I filed physically, then I have done this.
Rejected.
May I permitted to mention, my lord, from the daily cow list, my lord, serial number 13, my lord.
Yes.
In this case, my lord, settlement is going to be made between the respondent and...
What is going to be made?
My lord, I pray for-
Settlement of what?
with regard to the respondent regarding the loan, my lord, from Grameen Bank, my lord. Then 2 weeks time may be granted, my lord.
When do you want?
After 2 weeks, my lord.
After 2 weeks. Who is for the other side?
I will inform, my lord, Mukesh Kumari,
What is the serial number?
13, my lord. Serial number 1313.
13.
G, my lord. I will inform to the counsel for the bank, my lord, Mukesh Kumar, my lord.
As requested on behalf of the petitioner, place this matter on 2 weeks within first 5 cases.
My lord. All right.
My lord, may I be permitted to mention one case, my lord, listed at serial number 17, my lord. With consent, I pray that it may be taken up on Monday, my lord.
Let the matter be called. Where is who is for the other side?
My
Let
lord,
it be called. Please be here when the matter is called.
Lord, may I kindly withdrawal of this case?
Please send your slip.
Mentioning matters item number 1, CWJC number 1313364 of 21.
petition. Petition first to be mentioned. First evidence. Petition. Sorry.
Yes? Not your matter, Mr. Not this Tuesday. Next Tuesday. After opening.
Item 2, CWJC number 16795 of 21. Mentioning matter.
Yes?
Serial number 2, please, 1.
Same day. Tuesday.
Serial number 2.
Serial number 3,
Two.
CWJC number 1919280 of 21.
Huh?
All right, same day.
Regular matter. Under the act for to be mentioned from the regular list. Item number 1, CWJC number 1362602 of 15. Alok Kumar Ka versus the Union of India. For the petitioner, Mr. Hemant Kumar, Mr. Karan, Mr. Manoj Kumar Gupta. For the other side, Mr. Satyam Sundaram, Mr. Vaidehi Jaman Prasad Singh.
Who is for the CBI?
Mr. Bipin Sinha. Mr. Bipin Sinha.
You are for whom?
I am for respondent number 7, my lord. But I had filed slip for urgent hearing of the case.
Huh?
I had filed slip for urgent hearing of the matter. Because the stay is continuing.
Yes.
Lord, I have been asked to, I am not on advocate on record in this case, Lord, but on behalf of Mr. Hemant Karni, Lord, I have been asked to, if any date is fixed for hearing, we don't have any.
Tuesday first case?
Next week.
Today is Wednesday, we will take up the matter on Tuesday.
Okay.
You will have enough time to prepare yourself.
Milord.
What is the role of CBI? Some investigation has been ordered.
No, my lord. It was stated on behalf of the Additional Solicitor General that CBI investigation is pending against the petition, against respondent number 7, my lord. But that is not the fact. The counter affidavit has been filed on behalf of CBI, my lord.
There is no representation on behalf of the Central Bureau of Investigation.
My lord, his name is not appearing in the cause list, my lord, so his name may be printed.
Informed that name of Mr. Vipin Kumar Sinha, learned counsel who represents CBI before this court, is not appearing in the daily cause list. So stop list this matter on Tuesday with the name of learned counsel for the CBI appearing in the daily cause list.
For hearing, my lord.
And same heading. Under the same heading, let him come. If your matter is urgent, we will hear the matter. Finally, even irrespective of the heading under which the matter is listed.
My lord, my lord.
Item number 2, CWJC number 2509 of 18, the director versus Kaushal for the petitioner Mr. Vikas Jha, Mr. Ajay Kumar, Mr. Rohit Mishra.
Yes, Mr.
Lord, I am for the petition number 1 and Mr. P.K. Sai appears for petition number 2. My lord, the case has come on before your lordship on the sleep of the respondent number 1, my lord.
Yes.
Yes, my lord, I am ready. Argument. I have filed slip. I am on road since 8 years, my lord. I could have joined the post in the month of August 2013 in view of the DOPT letter, my lord, that I have annexed.
The only question involved in this case is as to what should be the date of preparation of panel.
Yes.
Is that the question?
Yes, my lord.
So both of you will have to answer this.
That is the listed, my lord. Date has been given. 3/1/13.
We will see that.
No, today is most probably any date your lordship may fix. My lord, the other day I had mentioned that I will be out of station
Monday.
till 11th. Monday.
But you are
For final hearing, my lord.
Yes, final hearing.
Yes.
Monday,
Yes, my lord.
the learned counsel for the parties agree that this case may be finally heard on urgent basis, on priority basis on Monday. So stop. Pleadings are complete. So stop. List this case on Monday to be taken up as the first case for hearing for final disposal.
Under the heading for judgment, item number 3, CWJC number 9706 of 20, Bhavni Kumari versus the Union of India. For the petition, Mr. Rakesh Kumar Srivastava. For the Union of India, Dr. Ken Singh Lani DSP, Dr. Mr. Ankit Kshatriya interview is
Let it come tomorrow.
My one thing, my lord, I pointed out, my lord.
Yes.
On the point of law, my lord. According to my lord, the circular, my lord. At page 47, my lord.
Page
in case
47.
47 of the my reply to counter supplementary counter affidavit.
Page 47.
47, my lord.
What for?
My lord. Reply to supplementary counter affidavit, my lord.
Page 47 of reply to supplementary counter affidavit.
That is the part.
Yes.
My lord, it has been stated in the voucher, my lord. In case the candidate does not submit the documents and or remit 10% of the security deposit, a reminder will be sent with the notice period of another 10 days, my lord.
All right. We remember.
My lord, if with this aspect, my lord, I left this this point of my argument that the lottery was done on 26/2019, my lord.
Yes.
And thereafter, my lord, the IOCL sent a letter for furnishing documents on 28/6/2019,
Right.
first, my lord. And according to these rules, my lord, that has been expired on 8/7/2019, my lord. But he sent reminder letter on 17/7/2019 after 9 days, my lord.
All right.
When I made complaint on 17/7/2019, then he sent letter for extension of 10 days, my lord.
All right. All right. Tomorrow. Yes.
May please order.
CWDC number 10274 of 20, Sanjay Kumar Jha versus the state of Bihar for the petition Mr. Rabindranath Modi for the state commission to Shastra CPK.
May please your lordship, my lord. By the order dated 8/12/2001, my lord. Your lordship has been pleased to direct that the DM should present here, my lord, with his so-called. So-called has been filed,
When?
my lord, and DM is present.
When was the so-called filed?
My lord, day before yesterday.
So yeah, we are proceeding against him.
My lord, your lordship, the explanation is that paragraph 6 and 7 of my so-called matter. The DO was actually engaged in panchayat election, my lord, on that particular date, when earlier order was passed to file counter affidavit, and failing which he should present my lord. On that particular date, there was election, my lord.
Then he could have filed an application for exemption.
My lord, but
He could ask anyone. He could have asked you
there was
to
missing-
prepare an affidavit.
My lord, there was missing of communication, my lord. Therefore, he regret for that, my lord, and apologize it.
there was no any intention, my lord. How could he have any intention, my lord?
When was the order communicated? When did he know that he has to file counter affidavit?
My lord, the order was communicated from this office, my lord, to the office of the DMI. But since he was engaged in area, my lord, to control the law and order, my lord, they could not contact my lord and could not place about that order, my lord.
No, but this order was passed in October.
My lord.
So we are in December.
The earlier order was passed, my lord.
Yes.
But on the last occasion when he was directed to appear filing contract with it.
What is this? This order, first order was passed on 15/7/2021. Then again 31/8/2021. We are proceeding against him. The affidavit is not there. The affidavit which he has filed is not here. We will proceed against him.
Your Lordship may kindly please to see paragraph 6 7.
In compliance of the order of this court dated 8/12/2021, the district, what is his name?
Mr. Sunil Kumar Yadav.
Mr. Sunil Kumar Yadav, the district magistrate Sitamarhi, is personally present. Full stop. It is stated by on his behalf that an explanation has been filed on affidavit in compliance of the said order dated 8/12/2021, justifying the reason why counter affidavit could not be filed despite repeated orders of this court. So stop. Whether now affidavit has been filed?
Yes, my lord. Counter affidavit has already been filed. And the grievance of the petitioner. So
when did you file it?
Day before yesterday, my lord.
Grievance of the petitioner may have been redressed. But I hope
has
this is not the stand you have taken in the show cause what you are submitting. How can you take both stand that there was no communication and that he was engaged? Either of the two stands you have to take.
That is not the particular stand, my lord. The stand is, my lord, there was missing of communication, my lord, from his office, and therefore he could not.
See the affidavit. We will see the affidavit.
There is one affidavit which was filed on 11/12/2021. This is counter affidavit.
Yes, my lord. And the payment of the as made the grievance, my lord, by the petitioner has also been paid.
Payment
We
has
will
not
see
been
that.
made. Payment has not been made.
We will see.
You accepted but not paid.
And except E is there, my lord, in the contract.
Is there any employee below the rank of circle officer in the district?
My lord,
Why the circle officer is swearing affidavit?
counter affidavit was.
Why? Why an officer of the rank of circle officer?
It is by the circle officer, my lord. He is also a respondent in this case, my lord. Circle officer.
This matter on Monday, along with the explanation said to have been filed on behalf of the district magistrate Sitamarhi. Stop. The district magistrate Sitamarhi will, though not be required to be present on that on so and so day. Stop. The court will consider as to whether proceed against him or not on the said date.
On the next day, my lord, DM is not required to present.
Next day not required to present, but if we decide to proceed against him, then they will be required to be present.
Item number 6, CWJC number 9554 of 21, Mr. RSPL Limited versus the state on behalf of the petitioner, Mr. Vivek Kumar and Mr. Ketusaram Pandey, for the state, Mr. Vikas Kumar, SPL Limited.
May it please, my lord. My lord, this case.
In this case, I was seeking passthrough of a few cases, my lord.
Why?
Vikas Kumar will assist your lordship in this case.
What is this matter about? Yes.
My lord, this matter is about industrial subsidy, my lord. The state came up with a policy to grant subsidy if the industrially set up industries in Bihar, in the state of Bihar.
He
Our
is seeking adjournment, should we grant?
For few cases only.
For few cases, it may be taken up today only, my lord. Else,
It will come tomorrow.
Tomorrow.
At the request of Land Council for the state of Bihar, discuss matter tomorrow.
Obliged.
Item number 7, CWJC number 1382/21, Kumar Shankar Ji versus the state of Bihar for the petitioner Mr. Gura Kumar, Mr. Shant Ankit, and Mr. Mr. Kavita Prasad.
May it please your lordship. Lord, initially this writ application has been filed, my lord, for quashing 2 orders, my lord. By the first order, my lord, my agreement, which was given to me for the purposes of, my lord, tenders, 10 tenders was, my lord, given to me, my lord, in the year 2015 for under the Prime Minister Gram Sadak Yojana, my lord, for building the roads, my lord, and to do the maintenance work, my lord. Now, my lord, cutting short this matter, my lord, this order has already been, because I had made an appeal before the empowered standing committee, and this empowered standing committee, after apprising, my lord, in the entire facts and circumstances of the case, was pleased to, my lord, annul this particular order, my lord. So now that order is not before your lordship, my lord, as a challenge, my lord. It has been stated in my rejoinder, my lord. By Annexure 10, my lord.
Yes.
So I'm not aggrieved by that order, because that order of cancellation of my agreement stands set aside by the empowered standing committee, your lordship. Now the second is, my lord, pursuant to that first order, based on the first order, my lord, they had passed an order by which they have debarred me from, my lord, taking part in any of the future tenders, my lord. This stays at my face, my lord, on 2 grounds, my lord. Number 1, no notice was given to me at any point of time.
Order?
Pardon, my lord?
Where is that order?
This order, my lord, is Annexure 8 at page 65. Annexure 8 at page 65, your lordship.
Now, since they have allowed you to execute the work, and that
Your lordship, now it comes to an admitted, my lord, facts, my lord, by the parties, my lord, that the initial work of, my lord, the construction of the road was completed, and a completion certificate was also issued. Now there is also a, my lord,
where is the order of debarment?
Pardon, my lord?
Where is the order of debarment?
Debarment. That order is, my lord, Annexure 8 at page 65, your lordship. This order has been passed, my lord, without providing me any opportunity whatsoever. And this order was, have your lordship got it? This is Annexure 8, my lord, at page 65.
Yes.
Now it says, my lord, in the subject matter, इकरारनामा के शर्तों के उल्लंघन के आलोक में. Now that very इकरारनामा which was cancelled, my lord, and which prompted the authorities to pass this order, particular order before your lordship, it is assailed on 2 grounds, my lord. Now the first order, my lord, now goes, my lord, by the empowered standing committee. So naturally, my lord, the repercussion will also be to this reflection, will also be to this order also, my lord. And this order is absolutely, my lord, without, my lord, any jurisdiction on the account of this fact, my lord, no notice was given to me prior to passing of this order, my lord. Had I been given that opportunity, I would have easily persuaded them, as I had persuaded the empowered standing committee, that this whole cancellation was bad, and that was accepted. And in fact, my lord, the maintenance rider was also there along with the main work, my lord, of the construction of the road, that you shall be maintaining this road for the next 5 years. Now, the entire thing comes, we are in 2021, my lord. And my lord, in 2000...
Mr. Chaudhary, why this P8 has been set aside?
My lord.
This annexure has been set aside by the empowered committee.
Annexure 10 may kindly be seen,
Yes,
my lord.
We have seen at page 109.
My lord.
Yes.
Now I stand corrected, my lord. Now the original and the my lord, they also have accepted, my lord, and they have also extended my time period, my lord. Now during that time period, there were 2 reasons, my lord, for not completing the maintenance.
Where is this 29/6/2021 letter?
20.
Please come to page 19.
My lord, I am very extremely sorry, my lord.
All right.
My lord,
Please come to page internal page 11 of your rejoinder.
My lord, I'm sorry, my lord. आपको बोले थे ना पेजिनेट करने के लिए. Lordship. Internal page, your lordship. Annexure 11. My lord. इस मामले की सुनवाई संवेदक उमाशंकर सिंह के द्वारा, यही ना हुजूर?
Yes.
कार्यपालक अभियंता के पुपरी के इकरारनामा विखंडन सच एंड सच के विरुद्ध 8/7/21 को समर्पित अभ्यावेदन के आलोक में की गई है। प्रश्नगत आदेश द्वारा कार्यपालक अभियंता ग्रामीण कार्य विभाग सच एंड सच इकरारनामा को विखंडित कर दिया था क्योंकि संवेदक के द्वारा प्राइम मिनिस्टर ग्राम सड़क योजना अंतर्गत आवंटित 2 पथ पैकेज सच एंड सच पथों में 5 वर्षीय रूटीन अनुरक्षण कार्य नहीं किया जा सकता है। मेंटेनेंस वर्क.
This refers to an application of 8/7 made by you.
My lord.
Where is that application?
That application has not been annexed.
So in that application, have you made the communication of 7/7 an issue? It has been filed just the next day after this debarment order.
My lord.
So whether this fact was before the empowered committee or not?
That was, my lord, before the...
So from where do you say that? Show us.
Your lordship will look into this order, my lord,
No,
first.
I am asking you a very specific
Your lordship,
query.
I am extremely sorry, my
The
lord.
debarment
I
order-
may be granted some time, my lord, to bring that on the record, my lord. Lordship.
No, you can go before the empowered standing committee.
You are required to raise it there.
No, your lordship, I am agitating one point, my lord, that they have passed this order, my lord, without giving me the proper opportunity.
Maybe you
And
can...
by now, my lord, there were 2 grounds, my lord. My lord, while I was doing my completion, this maintenance work, my lord, in 2020, on account of the advent of this COVID-19, my lord.
You can go, just come to the impugned order. This order was, sorry.
Pardon, my lord?
The order of the empowered standing committee was passed on 2/9/2021.
My lord.
On 2/9/2021, the empowered standing committee takes into account your challenge to the order dated 29/6/2021, not 8/7/2021.
हाँ तो इसलिए 29/6/21 by which the my lord the agreement was rescinded. That order was.
It does not take into account, Mr. Chaudhary, the communication of 7/7/2021, because you did not challenge that.
7/7.
Challenge that, yes.
My lord, it is challenged in this particular writ application. It stands challenged, my lord.
Mr. Chaudhary, you could have challenged that before this empowered standing committee. Why to the High Court?
My lord, because
Empowered standing
my lord is
committee has
perfectly right. I could have
considered
easily challenged that too also, my lord, before.
and challenge if you would.
My lord will kindly appreciate one aspect of the matter. This writ application was filed on account of, my lord, this order being passed at my back, my lord, without affording any opportunity
Chaudhary,
whatsoever.
making the same
On this
submission-
short, on this,
Making the same submission repeatedly is not going to help you. See, when the authorities have shown their bona fide and they have interfered with the order, where is the scope for this court to arrive
Then-
at a conclusion that if you had
then
raised
if
this,
you
they
if
would
you-
have not considered that?
if your lordship wants to relegate me to
No,
that.
no, whether you have raised it. When the
Nahi.
authority is
वो तो
considering,
raise
if it
नहीं
has
हुआ।
not been considered, otherwise why should you invoke the writ jurisdiction?
Then, my lord, an opportunity may be given to me, my lord, to raise this question, my lord, before the empowered standing committee. And I'll only beseech and humbly request your lordship, that there are 2 grounds, my lord. They are not making the payment for the, my lord, entire maintenance, my lord, done as, my lord, till date, my lord. 4 maintenance have already been done. I have entered into a completion of the 5th maintenance, the last one, my lord. These are the admitted facts, my lord. So on that account of matter, having not been paid that thing, my lord, that sufficiently, my lord, precluded me, my lord, from completing it within the date of completion, my lord. So on that account of the matter, I am humbly beseech.
You can go to them. Pardon.
Yeah.
The petitioner.
Your lordship, The appeal which I had, my lord, made before the empowered committee, my lord, that is, my lord, annexed, my lord, annexion 9, my lord, at page 71.
Of your rate?
My lord. ये सिर्फ उसी के बारे में है,
Yes.
इकरारनामा विखंडन के बारे में.
Obviously, that is why I said you must not have raised it. It appears from the order of the empowered.
Yes, your lordship. That is why, my lord. तो हम यही बोलेंगे हुजूर, when I am being relegated to that, my lord, I thought, my lord, if the notices are given, this honorable court will interfere on that very short question of the case, my lord.
The petitioner.
My lord, may I make one prayer, my lord, subject to your lordship's kind approval, my lord. My lord, that prayer will be to direct the empowered committee to decide my case, my lord, within any time your lordship fits things proper, my lord. And my lord will give me the liberty also, my lord, with regard to the payment of my, my lord, account, which has been completion certificate given, everything, my lord, not paying, my lord. And that has put a substantial bar, my lord, for me to, my lord, proceed in the matter, my lord. So that, only I can raise that issue and this issue particularly before the empowered standing committee, and the committee may dispose of my matter within any time your lordship reasonably thinks fit and proper, my lord.
Your lordship, may I say something in this matter? May I say something in this matter, if your lordship?
Yes, you have right.
Kindly see paragraph number 9 of my contract at page number 7. By the annexure B at page number 40. A letter has been communicated by the office of the executive engineer RWD to the petitioner, my lord.
Yes, we have seen this. We have seen this. This is what he had challenged.
My grievance is related to that, my lord, my learned friend.
Following are the reliefs which the petitioner is seeking in the present application under Article 226 of the Constitution of India. Let's stop. Next. Mr. Chaudhary, learned senior counsel, appearing on behalf of the petitioner, has submitted that the petitioner's first relief as regards challenge to the order dated 29/6/2021 has become infructuous with the passing of an order by the empowered standing committee of the Rural Works Department, Government of Bihar, whereby the said order has been set aside. Full stop. Next. This is apparent, however, that the petitioner did not assail the subsequent communication dated 7/7/2021, whereby the petitioner has been debarred from participating in future tenders before the appropriate authority / the empowered standing committee. Full stop. Next. Full stop. It is observed that the petitioner shall have the liberty to assail the said order dated 7/7/2021 before appropriate authority. Full stop. If he does so within 2 weeks from today, the court expects that the competent authority shall decide the same within a period of 2 months thereafter. Full stop. Next, in respect of other reliefs as sought for by the petitioner, it is observed that the petitioner shall be at liberty to pursue his matter before appropriate competent authority for payment of bills. Stop. This application stands disposed of. Public.
Item number 8, EWJC number G15223 of 21, Mr. Bhaleshwar Nath Construction versus the State of Bihar, for the petitioner Mr. Lal Babu Singh and Mr. Umesh Kumar Gupta, for the State, Mr. Arjuna Meenakshi, DPC.
Lordship, kindly pass over for the few cases, Lordship. The arguing
Cases we
counsel is
don't
busy
do.
on
We will come tomorrow
all eyes, Lordship. All eyes.
as requested on behalf of the petitioner. List this matter tomorrow.
Item 9, CWJC number 15782 of 21, Manish Kumar versus the State of Bihar. For the petitioner, Mr. Prakash Srivastava. For the state, Mr. Rajiv Rai, EP1, Mr. Purushottam Jha, and Mr. Girish Pandey.
May I please, Lordship? My lord, I am appearing on behalf of respondent number 5, my lord. In this case, earlier Mr. Purushottam Kumar Jha appeared, but now he is no more, my lord. I am newly appointed and copy is not.
Yes. Yes.
Milords.
Mr. Srivastava, so we should adjourn the matter. The ground which is.
No, I will serve copy to my lord from today itself, my lord.
There are two matters.
3 matters, my lord.
3 matters.
Milords.
All right. These are the cases which you are arguing.
Milords.
These are urgent matters, Mr. Counsel.
My lord, I am appearing on CWJC 15782, my lord, Manish Kumar Singh.
And in other
Number
cases,
1.
who is appearing? You are appearing for whom?
Municipal Corporation, Madhubani.
Madhubani.
Respondent number 5.
Respondent number 5.
Mine.
So you can appear in all the cases.
No, my lord. Nagar Nigam Madhubani ka. One is from
Municipal
Motihari.
corporations are different.
Milords.
All right. So in other cases, who are they?
Copy has already been served on their councils, my lord.
Who is appearing for Betia?
Bethian and Motihari hai.
Motihari. And
And my lord, one is Rajgir, my lord.
who?
For Rajgir there is no council, my lord.
There is no counsel.
Yes, my lord. On behalf.
Rajgir. Then? So we can take up the matter when? Monday?
My lords.
Monday, Mr.
I will serve copy upon my lord friend today itself, my lord.
As jointly as requested on behalf of the respondents, list this matter on Monday within first 10 cases.
CWJC number 16911 of 21, Rajendra Prasad Singh versus the State Election Commissioner. For
My lord.
Mr. Upendra Kumar Singh.
My lord.
Mr. Kumar Sinha.
This petition, my lord, in the nature of certiorari, Rai, my lord, to quash the letter issued by the district panchayat officer, my lord, come district magistrate Rohtas, my lord,
Election is going on.
dated 8/9/2021, my lord.
Where is that? Which communication you are challenging?
My lord, Annexure 2, page 21, my lord. Letter of district magistrate, my lord. My ground is that, my lord, due to their engagement in panchayat election, my lord, admission and examination, all are hampering, my lord.
We don't have any jurisdiction to entertain such matters.
My lord, earlier, my lord, by this honorable court, my lord, order has been passed that the teachers cannot be engaged in panchayat election, my lord. The order has been passed by the Honorable Mr. Justice Sukriti Singh, my lord. May I kindly see the order, my lord?
Interim order.
My lord.
Interim order.
My lord.
I was appearing.
My lord? No. I was not appearing in that time. But order had been passed.
After that order was passed, Mr. Counsel.
No, my lord is that. No, my lord is not.
The act has been amended. Mr. Counsel, this order was passed.
My lord.
This order was passed when there was no provision requisitioning the employees of the university, and therefore this interim order was passed.
My lord.
Yes.
Lordship, kindly see section 125.
Yes, that has been amended after this order.
Lordship, and order has also been passed by this honorable court, Lordship, thereafter, Lordship, in the light of amendment, Lordship.
Yes.
But City and College are facing very hardship, my lord, due to their engagement, my lord.
Hardship is difficult. Hardship is difficult. Where is that decision do you have?
Lordship, I have a copy of the order. My lord has also passed an order, Lordship, in 2017, Lordship. In Patna University matter.
City and College teachers, my lord, are very old, my lord, 65 years old, in age of 65 years old, my lord.
So this is of which district? Sasaram?
My lord, Rohtas.
Elections are still going on.
Elections are over, Lordship.
Then
Started 12th December.
2021.
12th December, my lord, election is over.
Then this application has become infructuous.
My lord, for further
Future.
election will again come, my lord.
Again come is very difficult. Then again come. The petitioners have questioned the action of the respondents in requisitioning their services for Panchayat General Election 2021. Stop. It is an admitted fact that the election for which the services of these petitioners were requisitioned has already been held. So stop. This application, in our view, has thus become infructuous and stands disposed of accordingly.
Lordship, I pray for passover for few cases, Your Lordship. Senior counsel has to argue, Lordship. Few cases, one or two. One or
They
two.
will not on Monday because tomorrow is hearing day, and it is supposed that tomorrow I will have first case for hearing before Honorable Second Division.
They are pressurizing for
Monday. They are pressurizing.
yes, for removal of my catering stall, and that's the matter.
You begin. We are here. You can start. You are advocate on record. We will wait for him. You must have prepared the petition, drafted the petition.
Right.
You begin.
Your Lordship, the petitioner's catering stall at Patna Junction and Kiul railway station, they were directed to be removed with effect from 1/11/2021 for the reason that the demand of rupees 1,91,000 and odd amount was not deposited by this petitioner. This I have annexed to Your Lordship annexure which was challenged. The relevant is Your Lordship annexure 12 at page 67. At page 67.
Yes.
May I place, Your Lordship?
Yes, please.
The subject matter arises in compliance of order dated 30/10/2018 of Honorable Supreme Court in so and so. In context of the order,
all the existing catering units of the licensee or partnership firm had been offered for the renewal on their application, but licensee failed to comply the offer of renewal of units on payments of revised license fee. Therefore, non-compliance of order of Honorable Supreme Court lies upon the licensee. Railway has complied the Honorable Supreme Court's order by offering him a renewal proposal with effect from 1/11/2018, that is one day after order of Honorable Supreme Court. To avoid further accrual of license fee as dues, following action is required urgently. 1. All the catering units of the licensee should be closed after completion of renewed period. Second, for the realization of all the dues, the licensee should be debarred and blacklisted from participating in any tender floated either by Railway or IRCTC over Indian Railway, besides taking other legal action against the licensee. Lordship, uh, order of Honorable Supreme Court is relevant. In compliance of that order, renewal of license has been made with effect from 1/11/2018.
Where is the order of the Supreme Court?
Lordship. This is page 68, annexure 13. May I place your Lordship?
उसमें वो पहले वाला ऑर्डर नहीं लाया है आप 2016 वाला, उसके बिना वो ऑर्डर कंप्लीट नहीं होगा। ये मंगवाइए ना 2000। परमिशन ले लीजिएगा तब हम पास करेंगे, अभी नहीं तो परमिशन ले लीजिएगा।
You are a partnership firm?
Lordship, yes, yes.
Please May I request so that Mr. Sai may appear?
I'm sorry, my lord.
Yes,
Yes, we were party,
you were partners.
partnership firm.
Yes, partnership.
Pursuant to direction of Honorable Supreme Court, my lord, the licenses were renewed under catering policy of 2010.
Yes.
Which will be apparent from page 58, if my lords will kindly see. Page 58 for a moment.
Yes.
This is from Ministry of Railway to all
Yes.
general managers. Pursuant to judgment of Honorable Supreme Court of India on the subject, instruction for implementation of judgment of Apex Court has been issued by its board letter of even 15/3/17, commercial circular number so and so. In continuation of commercial circular, it is clarified the tenure of renewal until the basis of renewal and revision of license fee on renewal will be governed by extant guideline mentioned in catering policy 2010.
Yeah.
Coupled with this, if my lords would kindly
So
see,
this is the judgment, Mr. Sai, which is reported in 2016 volume 3.
that was my lord the first judgment, and this the order which my lords were reading just now was my lord certain modification in that judgment. Yes, because in that judgment only one license was allowed, but later on Honorable Supreme Court modified it and said that partnership, cooperative and HUF etc. will not stand in the same status.
In page 58, the judgment which is being referred to, judgment of Supreme Court dated 29/1/2016, is the same judgment which is reported in 2016 volume 3 SCC.
Yes,
582. This has been referred to in that decision.
582.
Please come to page 69. Yes. Yes, this is the judgment.
Same judgment.
Same.
Same judgment. 618. It is the same judgment.
Yeah, right.
Now, my lords, we continue to be licensee in terms of catering policy of 2010. That stipulates, I will come to my lord catering policy. That stipulates that at the time of renewal, license fee will be revised, minimum will be 10%, and what will be the maximum will depend upon an assessment of my lord turnover, sale, etc. And then it will be revised. But without my lord making an assessment of sale in peaks, 3 peak months and 3 lean months, it will be not less than 10%. Now here is a case where my lord revision is almost 400% of license fee. This kind of, my lord, situation has been considered by this.
Come against revision. You have come against revision.
Revision, and my lord, during pendency of this writ application, they have issued a communication stating that since you have not paid the revised license fee, therefore your license which would be expiring on 30/11/2021 will not be renewed. So I have challenged that by an IA. That IA may be allowed, my lord. IA number 1.
1 of 2020.
IA number 1.
All right.
Have you filed your affidavit in terms of paragraph 34 of the Apex Court judgment?
Yes, my lord, there is no dispute to that. We were granted license pursuant to, my lord, direction of Honorable Supreme Court. The dispute is only confined to, my lord, arbitrary revision of license fee.
No, you have submitted your affidavit in response to paragraph 34.
Yes, my lord, then only my licenses were renewed.
Otherwise, license could not have been renewed. This kind of
Please, Mr. Sai.
ज्योति बाबू का जजमेंट होगा। देखिए if my this issue
What is the date of your renewal, Mr. Shahi?
renewal
After Supreme Court's decision?
1/8 no, first was 1/8/2011. After Supreme Court, my lord, it was in 18.
Subsequent Supreme Court.
Yes, that was 1/11/2018 for a period of 3 years. For a period of 3 years. Now, if my lords permit, I will, my lord, be showing to my lords that precisely the same issue has come up for consideration before this honorable court. In my supplementary affidavit, that judgment is there. If my lord should kindly come to my supplementary affidavit, and that judgment is page 14, annexure 20.
And what is the date of this judgment, Annexure 13?
Annexure 13.
Yes, the Supreme Court's order.
Supreme Court's order is, my lord,
30/10/2018.
Mr. Sahi, your renewal was not because of this decision. Your renewal was even otherwise, with effect from 1/11/2018.
No, my lord,
Are we clear?
It was, my lord, only based on that judgment that renewal was.
No, because this judgment was delivered on
30.
30/10/2018.
Yes.
And your license was renewed on 1/11/2018.
1/11/2018.
So if something was to be complied with in terms of this decision of Supreme
Actually,
Court.
we were continuing, my lord, from before. I was given license in 2011.
Right.
And then, my lord, dispute arose only on account of the fact that they had, my lord, terminated it and put the stalls
No,
on.
our question was for a different purpose altogether.
Yes, my lords.
We wanted to know whether your license was renewed with effect from 1/11/2018 because of this decision or without this decision.
Very well, my lord, that I have not answered. And it would be inappropriate to, my lord, make an impromptu.
Right.
There is, see, just para 34 is quoted in that order. That requires declaration that you are holding just one license and not more than one. And only upon such affidavit the renewal is contemplated.
Actually, my lord, my lord, the license renewal order was issued on 11/12, but with effect from 1/11/18.
Right.
That is on page 36.
36.
36. And it was in compliance of Honorable Supreme Court order, my lord.
Yes.
ये रिन्यूअल कब हुआ? लेकिन इसमें 11, 12, 20 को नहीं ना हुआ।
Page 36.
ना तो गलती बुलवा दी आप। प्रॉब्लम आप लोगों के साथ वही है।
That is not clear, my lord. आप गलत क्यों बुलवाते हैं हमसे?
It is.
This letter would show that it was renewed with effect from 1/11/18 pursuant to direction of the Honorable Supreme Court. Only
Right.
this much.
Right.
Yes.
This is what we wanted to know.
Yes. Pursuant to that. Before I, my lords, answer and take my lords to various facts, I was only trying to, my lord, show that this issue as to how license fee will be revised has been considered. It is no more open, my lord. In my supplement.
Mr. Zahi, the core issue involved in this case is the revision of license fee.
And my lord, retrospectively, kindly appreciate there are two facts. कोरोना पीरियड का भी है, कौन सा असेसमेंट इन्होंने किया, और ये जजमेंट देखिए, इसमें इसी प्रकार का काम हुआ था. Annexure 20, that is page 14 of my supplementary affidavit.
You are aggrieved by quantum as well as retrospectivity, both?
Both.
Supplementary affidavit page?
Internal page 14. My lords could get it.
Yes.
Yes. From page 15 I am placing, my lord. Fact remains that contract subsisted between parties when impugned assessment order was passed on 25/6/13, revising license fee of 3 stalls in light of catering policy 2010, henafter referred to as so and so policy. At the time of renewal of license fee should be enhanced, reassessed based on actual sales turnover of the unit. License fee will be reassessed and revised at the time of each renewal, subject to minimum of 10% increase over the prevailing license fee of the unit. To arrive at a realistic figure, Zonal Railways will ensure that a fresh assessment of sales turnover revenue is conducted during peak period and lean period with periodicity of 3-4 months in order to assess the actual sale turnover so as to fix the revised license fee. Renewal will be done for existing licenses only on withdrawal of court cases by licensees, if any, against so and so railways and payment of railway due. According to the policy, an enhancement reassessment of license fee had to be done after taking into consideration realistic figure relatable to sales turnover of 3 months each during lean period and peak period. Whereas it is case of petitioner, the railway authorities never carried out any such inspection. This fact is denied with reference to order of assessment placed at annexure so and so, which is the basis of impugned order. It is the case of petitioner that not only assessment order is divorce clause 18(3) of railways policy, in as much as respondents have failed to take note of the turnover of 3 months each in lean period and peak period, but even when matter is pending consideration before this court, railway authorities have gone ahead to terminate license of petitioner, wide order dated so and so, placed at annexure 9, which has been questioned by petitioner by filing IA, and have also demolished one of the catering stalls situate outside the railway building but within railway station premises, adversely affecting right of petitioner as well as causing him financial loss. Petitioner has questioned this action by filing IA. I have heard learned counsel for parties and I have perused the materials on record. No amount of justification by Mr. Sinha to assessment order placed at annexure so and so would persuade this court to uphold either the order of assessment or consequential order of revision dated itna impugned in writ petition or order of termination of license dated 4/3/14. Reasons are not too many. Rather, plenty speaking, assessing authorities have failed to carry out the exercise of assessment in the manner prescribed under catering policy as found in clause 18(3) thereof. The assessment order itself reflects inspection only on 3 consecutive dates, 6 to 12, 7 to 12 and 8 to 12. When policy requires an inspection and verification of sales turnover for 3 months during peak period and 3 months during lean period, the undue haste shown by Railway Authority in proceeding to cancel the license of petitioner and which is followed by demolition of one of the stalls, the action of authority is patently illegal, malified and difficult to uphold. On this ground alone, assessment order placed at so and so to the counter affidavit and consequential order placed at Annexure 1 together with order dated itna cannot be upheld and are accordingly set aside. Writ petition so and so is allowed since third stall of petitioner has been demolished by Railway Authority, showing unwarranted urgency. They would be under duty to provide alternative third stall to petitioner. They would be also under duty to return the material which according to Mr. Sinha is in safe custody of Railway Authority. In case the Railway Authority failed to return the material which were found to be demolished stall, they would be liable to recompense the petitioner for loss, the exercise for providing so and so. This order was taken in LPA and LPA court, my lord, found nothing wrong in the judgment of this court. So it is, my lord, cannot be disputed. In their counter affidavit, my lord, they nowhere say that assessment has been made based on any assessment as provided in catering policy of 2018. Railway Board, I represented before Railway Board. Railway Board has said that what you have done is not correct. Kindly come to my lord Annexure 9 for a moment. This is communication from Railway Board. Page would be, my lord, Annexure 9, page 64. On my representation, Railway Board says,
yes.
Page 64. Kindly see, my lord, Principal Chief Commercial Manager, East Central Railway, Hajipur. Subject, arbitrary increase of license fee for static unit by Danapur and Samastipur division of ECR. Representation dated 1/3/21 of Messrs. Express Food Services. This refers to above mentioned representation wherein issue of arbitrary increase of license fee for state units by Danapur and Samastipur division of ECR has been raised. Ministry of Railways had issued instruction-wide circular number 2217 dated 15/3/17 for renewal of contract after judgment delivered by Honorable Supreme Court. Further, wide board's letter dated so and so, the issue with regard to tenure, revision of license fee or renewal of the fee of the renewed units was clarified, and it was advised to follow the extent provision of catering policy 2010. It has been brought out in the enclosed representation that while issuing the renewal letters by Danapur and Samastipur division of ECR, due process of renewal and revision of license fee as mandated has not been followed. In view of above, it is advised to look into the matter and review the license fee of renewed unit as per extent policy in this regard. Further action should be taken after the matter is examined and review done as per extent policy. In response to this, in counter affidavit, they say that all these East Central Railway and the officials, they are autonomous and independent body, they can take independent decision. For the first time I am hearing, my lord, that a zone of railways is so independent that it, my lord, can avoid or disregard direction issued or advice tendered by the Railway Board.
second paragraph does not say the last. You were referring to third paragraph of this. It has been brought
out in the enclosed representation that while
this is not the opinion of the railway board. It is just
it is my contention.
Right.
But railway board says that this requires a relook, reconsideration,
Right.
and any action should be taken only after that.
Right. As per the extant policy.
That's right. As per policy of 2010, they do not justify, my lord, that what they have done is in accordance with clause 18(3) of 2010 catering policy.
No, Mr. Sahi, this is innocuous kind of communication. It just takes into account your representation and advises the authorities to have a real look and give effect to the policy dealing with revision.
That's right.
So this is the advice of the board. So the main question is whether the revision is in terms of the policy, in accordance with the policy, whether the process has been followed as laid down in the policy for revision of.
So
these are the.
My lord, there are only two ways license fee can be revised. One, that minimum 10%, and second, my lord, there is a method prescribed of revision.
So they will have to demonstrate.
They have to demonstrate that they have followed that procedure, made an assessment, and then only revised. And revision, my lord, kindly appreciate, this period also includes COVID period.
But before they are called upon to demonstrate, you have to make out what has not been done. What is your assertion that this part of the policy has not been followed?
I have stated, my lord, that there is no assessment. There is no, my lord, consideration by railway authority.
On 3 consecutive dates, they were required to make an assessment.
Not 3 consecutive dates, my lord. Periodicity is of 3 months lean period and 3 months peak period.
No, I don't think so. Let us see.
Yes.
That the judgment that which you are relying upon, that has subsequently a clarification has been issued in 2015, which has been considered in the order of review. That now the position is that only 3 consecutive dates an assessment has to be made, no assessment of lean and mean period. But the Honorable Court has considered it in this view of the matter that since this issue is prior to clarification, therefore clarification was not applied in that case. But that 15 clarification will apply in your case, only 3 consecutive dates. So whether you have stated that on 3 consecutive dates it was not done. Have you said so?
I have said that they have not followed 18(3).
That 18(3) is.
I have said that there is no assessment. Well, I am asserting, my lord, I am asserting that there is no assessment. They have not followed.
Where have you said that there was no exercise undertaken at all before revision?
Yes, my lord will kindly come to. Kindly permit me to place, my lord, paragraph 12 onwards.
Please wait, Mr. Sai.
Page 8.
Please wait, Mr. Sai.
All right.
Just a minute. Yes. Yes, Mr. Sai.
My Lord, para 12 onwards, that since aforesaid impugned letter, fixation of revised license fee was made in arbitrary manner with effect from 1/11/18, the petitioner submitted a representation on 2/1/21. I pause here for a moment. My Lord, how can they make an assessment in 2018? They are making, my Lord, revision with effect from 1/11/2018, which according to them is based on assessment of sale. Principal Chief so-and-so, by which petitioner made a request to concerned authority to reconsider the said fixation of license fee. Through aforesaid representation, petitioner dealt each and every point in support of his case and stated that Office of Senior Divisional Manager, East Central Danapur has issued renewal for said catering unit in order to implement the Supreme Court order and subsequent instruction issued by Ministry of Railways while issuing renewal letter. A due process as per mandate of Railway Catering Policy 2010 has not been followed, and revised license fee has been enhanced drastically in unreasonable manner. It was pointed out petitioner that fixation of said revised license fee is contrary to provisions mentioned in Railway Catering Policy 2010, which mandates that at the time of renewal of license fee should be enhanced, reassessed based on actual sales turnover of unit. License fee will be reassessed and revised at the time of each renewal, subject to a minimum of 10% increase over prevailing license fee of the unit. Copy of said representation was also submitted to General Manager so and so, so and so. सर हम नहीं ना बोल रहे कि इनको काउंटर देना है।
Whether 18.3 exists as on date?
Yes, my lord, that exists. Every
and whatever you have seen the clarification to 18.3 issued. Have you seen the clarification which has been issued to 18.3? Please come to the judgment that you are.
Yeah, I have seen that in review.
Yes.
In review.
That stands reviewed. It says now only 3 consecutive dates it has to be done. And your representation claims that it was required to be done in the lean period and the peak period.
Yes, my lord.
Therefore, that issue is not relevant anymore.
My lord, nonetheless, there has to be some basis for it.
So therefore, see, this is a contract and commercial activity. What is the infraction complained by you? If this is the only infraction, this is no infraction. Otherwise, why they should be called upon to respond in such matters?
Kindly appreciate
of contract.
Kindly appreciate, my lord, revision, my lord, in some cases 400 to 600%.
Maybe, but we don't know whether that is obnoxious or that is after how many years. Those are issues of commerce. You can get it decided at the appropriate forum.
Where is there is no appropriate forum.
See, the board asked them to reconsider the issue. They have reconsidered it.
No, they have not reconsidered.
Oh yes, that is your annexure 11.
They have not reconsidered.
Yes, they have considered your representation after that.
My lord, with great respect, they have not considered. That
is the order after the railway board's observation that it requires review. This is 21/9/2021.
Yes, my lord, I have seen that.
Then It is not their case that they are saying we will not consider it.
No, what they are considering, it should be noted here that divisions are having independent authority for the purpose of award or renewal of any contract and no appeal lies against them. This is no consideration.
But there is no ground for invoking the writ jurisdiction merely by saying that it is excessive. Should we interfere in every contract because there is an assertion that it is excessive or inflated? There has to be some infraction of the procedure prescribed. Then only there is a scope. That also if it is in larger public interest. You are aware of the present trend.
My lords, what can be more graver in my lord public?
It appears the petitioner was under some kind of confusion. See, he has stated that that process was not followed. It is a specific assertion. Come to page 41. What he has said in his representation. Please see paragraph 6, what he has said. That is the basis of the entire writ proceedings, that this has not been followed. He thinks it is still required that there has to be an assessment during peak period and lean periods. This has already been
my lords, with
clarified.
great respect, my lord, a vendor, a catering vendor, a small catering vendor is being asked to pay, my lord, 500%, 600% license fee retrospectively with effect from 1/11/2018.
Therefore, we had observed that your sale is on two grounds, one on quantum and the other on retrospectivity.
Yes, my lord.
Insofar as quantum, we are going through things and it appears that there is no, but regarding retrospectivity, of course, we will ask them to respond, whether it can be such penal liability can be fastened on you with retrospective effect or not.
भाई जब बात कर रहे हैं आप ऐसा बहस हम करेंगे क्या?
No, Mr. Sahi, in fact, speaking for myself, I am not clear about the policy. The catering policy you are referring to.
I have not enclosed entire catering policy, only extract of that policy has been
The relevant
enclosed.
extract will do if the facts are admitted, if that part of the policy is admitted, then sufficient for us to
Yes.
interpret and decide. But this, your entire case before the railway board and even subsequent, your case is based on 18.3. 18.3 as has been quoted in paragraph 41, page 41, paragraph 6 of your representation. You are relying on that only. Whether that exists or not in the same form as it has been quoted.
My lords, that exists with slight modification.
Then that is the whole
Modification is lean period and peak period. But rest of it exists.
Then your representation is of 2021.
Yes, my lord, only when they make a demand.
Then you could have told them that this is the method, this is how the...
I have already, my lord, I have submitted 3 representations to them.
No, but on the basis of this, which has been quoted,
18.3. They say that my adjacent stall has been put on auction and the license fee by that auction purchaser is comparable with what we are asking from you.
That is different. That is the query was.
हमारा हुजूर मेरा के दूसरी बात बोल रहा है ना, वो कह रहा है 3 consecutive dates नोट किया हुआ। He sent a sense a second 3 consecutive dates नहीं, this has been affirmed by the division. यही जजमेंट के लिए मिलेगा, रिव्यू वाला भी गया ही कहता है कि मैं 14 में आ गया कि सिर्फ 3 consecutive dates नोट see that. हुजूर एक अनुरोध करूं,
Yes.
इसको आज सिर्फ पास ओवर कर दीजिए। मैं 2010 पॉलिसी इन्फोर्स है कि नहीं है, और वो अगर इन्फोर्स है तो किस मॉडिफिकेशन के साथ है, ये मैं आपको कल I'll deal with it. Only this much. In what form it is enforced or it is not enforced, I'll kindly accommodate me for today. हमको कोई दिक्कत नहीं।
Yes, tomorrow, Mr. Sinha.
My lord, I prayed for Monday, my lord, because tomorrow is the hearing day.
We will take up the matter because we have heard the matter at least. We said take up the matter on priority basis so that time is not wasted. We will again be required to recapitulate the factual aspects. Tomorrow we will take up as first case. Tomorrow first case. So that and Mr. Sinha,
my lord,
there are 2-3 aspects. One, as we have observed about 18.3 and subsequent change in the policy, whether we can go into all those policy aspects and contractual matters or not is another. You will have to address this court on the question of retrospectivity while revising the license fee. Whether you can justify whether today if you say someone that your license fee is increased from say 2 years back, and you are attaching that liability on the licensee, and whether that can be sustained or not. So these are basically two aspects.
For that, my lord, when my friend is seeking time for tomorrow, my friend may produce, or I can produce, my lord, the advertisement and agreement, original agreement, because first agreement is for the certain period, and then it is mentioned that after renewal of the license, certain fees will be charged. So we are charging every year, not paid, that's why we have issued notice. And now the situation is on 31st
No,
of...
when did you fix the license fee as on say 18? So we are forgetting the date.
1/11/18.
1/11/18. When did you fix?
In 21.
When did you fix the license fee as on 1/11/2018?
First agreement itself.
And you are charging accordingly?
Accordingly.
Up to 2021?
Now, my lord, yes, and now on 31st of October 2021, his agreement has lapsed.
All right.
Everything is complete.
All right. So with effect from that date, if you again renew his license, its license, you may be asking the petitioner more license fee on the revised rate. But how can you do that with effect from 1/11/2018?
I will explain you.
These are two issues, Mr. Sahi. There are 2 issues. We will
If you are relying on any documents, we will request you to kindly pass it on to the court during the course of the day, so we can also see it before we.
I'll do, my lord. I'll do.
We'll come back within 5 minutes.
CWJC number 18316 of 21 Brajesh Kumar versus the State of Bihar for the petitioner Mr. Vikas Kumar, for the state Mr. Raza Ahmed, age 5.
May I please, my lord? My lord, writ application has been filed against the order by which petitioner has been debarred from participating in future tender for indefinite period.
File appeal.
And that too, no, my lord, that too without any so-called notice, my lord. There is no provision of appeal, my lord.
Where is that?
My lord, that is page 15, my lord. Annexure 1. Without any so-called notice, my lord.
You must have done something very serious. Where is that?
Pardon, my lord.
Where is the
My lord, on the last paragraph, उपरोक्त वर्णित तथ्यों एवं जांच निवेदन तथा विभागीय निर्देशों के अनुपालन एवं इकरारनामा के अनुसार कार्य निष्पादन में चूक के लिए सम्यक विचारोपरांत एवं बिहार ठेकेदारी निबंधन नियमावली 2007 की कंडिका 11 का की उपकंडिका 2 के आलोक में तथा विभागीय आदेश संख्या 100 एवं अधीक्षण अभियंता लोक स्वास्थ्य अभियंत्रण गया अंचल का पत्रांश के अनुपालन में संवेदक My lord, in these rules also it is, my lord, in those rules there is no power for debarment, my lord. There is a power of blacklisting and demotion under these rules, my lord. And even that, my lord.
What is the difference between blacklisting and debarment?
My lord, debarment and blacklisting are different, my lord. Debarment is participating in any future tender, and blacklisting, my lord.
Both are the same.
But effect, Mr. Effect of debarment and blacklisting is same.
My lord, but that also provide, my lord, that
Mr. Some order has been passed. Order has been passed under the rules. You have a provision for appeal. You can prefer. You
my
can
lord,
go to the
prefer an
appellate
appeal, my
authority.
lord, but there is a violation of principle of natural justice. No so cause has been given, my lord. Even in that case, in that rule also it has been
Tell the
provided.
appellate authority. You can tell the appellate authority.
My lord, there is so many judgments, my lord, if there is
Then
a
we are delivering judgment today that in such matters you must first approach the appellate authority.
my lord, that too without indefinite period,
All
my
right.
lord.
We are delivering the judgment today that in such matters, even on the ground of principles of natural justice, even if you have to take this plea, you can take that plea before the appellate authority. Why writ court? How writ court is convenient, more convenient than the appellate authority? Explain us.
Lord,
explain us. You have straightaway come to the High Court.
My lord.
You should have, the petitioner could have filed an appeal and could have stated that I was given no opportunity of hearing.
My lord, that's why there is a judgments, my lord, of the Honorable Apex Court.
There are judgments, yes.
Honorable Apex Court
Yes.
also that if there is a, my lord, there is a violation of principle of natural
We are
justice.
delivering judgment right now. We are right now delivering judgment. And in such matters, you must approach the appellate authority first.
My lord, today it may kindly pass over, my lord, tomorrow.
Why pass over?
My lord, the judgments, my lord, on
Why
which...
judgment? You can test the judgment.
No, I will not test it, my lord.
Why should you not?
Lord, I will just show, my lord, those judgments, my lord, if there is a violation of principle of natural justice, my lord.
If there is a violation of principles of natural justice and if the order is without jurisdiction, the writ court may exercise jurisdiction, does not mean shall exercise jurisdiction.
But
we are conscious of the legal position which you are trying to place by virtue of judgments. It is not something which remains to be decided. It is well settled. It is within our jurisdiction that in an appropriate case where there is complaint of natural justice or without jurisdiction, even if there is an alternative remedy. In your case, these are contractual disputes. The Honorable Apex Court recently it has said that in such matters writ court should stay clear and avoid getting into these issues. It is a matter of trade and commerce, public convenience, public interest. You go before the authority. If you don't get your redress, the forum is always open to you again.
My lord, my submission is only that because of in violation of principle of natural justice, the order has been passed. This is my submission. If my lord is relegated me to the appellate authority, my lord.
We will dismiss your application on that ground. That's all.
It may kindly be disposed of, my lord, giving liberty to file appeal before the appellate authority.
We have not stopped you. We are not stopping you.
But in certain time frame, my lord, I will approach to the appellate authority, my lord. A time frame may be given.
Is there any time limit? Is there any time limit? Have you seen the rules?
दिए गए दंड के विरुद्ध संवेदक द्वारा 30 दिनों के अंदर आयुक्त एवं सचिव के समक्ष अपील दायर किया जा सके।
What is the time?
What is the time period?
Within 30 days, my lord. दिए गए दंड के विरुद्ध संवेदक द्वारा 30 दिनों के अंदर आयुक्त एवं सचिव के समक्ष अपील दायर किया जा सके।
You did not prefer. You did not prefer the appeal within 30 days.
Lord, I filed writ application, my lord.
4 months thereafter. You filed the writ petition on when? On 23/10/2021. So therefore, the petitioner, are you registered under the rules? has received an order dated 36/2021 issued by the Executive Engineer, Public Health Division Gaya, whereby the he has been debarred from participating in future tenders of the state government. Future tenders. Stop. The order has apparently been issued under Bihar Contractors Registration Rules, 2007. Full stop. 2007, invoking Rule 11, Sub-Rule 2 of Rule 11, bracketed K of the rules. Full stop. This is not in dispute. Mr. Vikas Kumar, learned counsel, appearing on behalf of the petitioner, has submitted that the impugned order has been passed in violation of the principles of natural justice, inasmuch as before issuance of said order, no opportunity was given to the petitioner to submit his representation against proposed action of debarment. So stop. He has further submitted that the order of debarment is for an indefinite period, which is impermissible in view of the law laid down by the Supreme Court and this court also. Stop. Next. Be that as it may, the petitioner has alternative remedy of appeal under the rules of 2007 itself, which the petitioner has not invoked. Stop. Considering the facts and circumstances, this writ application is disposed of with a liberty to the petitioner to approach the appellate authority against the impugned order. Stop. On noticing the provisions under the rules, it is evident that limitation of 30 days is prescribed for preferring appeal before the appellate authority. Stop. In such circumstance, it is observed that if the petitioner prefers appeal before the appellate authority within 2 weeks,
my lord,
from today, the appellate authority shall condone delay in preferring appeal and decide the petitioner's case on merits, particularly the contention that the impugned order has been passed without giving petitioner any opportunity of hearing, and term of debarment has been arbitrarily and no term of debarment has been stipulated in the impugned order.
Any time frame, my lord? Any time frame? If I will file within 2 weeks, my lord, thereafter, my lord.
Debarment of a contractor has serious consequence. First off, it is therefore observed that if the appeal is preferred within the aforesaid period of 2 weeks, the same shall be disposed of must be disposed of within a period of 2 months thereafter. So you could not get any better order, Mr.
Obliged, my lord.
Vikas
Obliged.
Kumar.
Much obliged.
Item number 14, CWJC number 975 and 9755 of 20.
May it please, my lord. My lord, yesterday, my lord, in the lead case, my lord, counter affidavit has been served upon me, my lord. I just seek a 2 days accommodation, my lord. If this batch matter may come upon Monday, my lord. नहीं, इसमें कर दिया गया। अनिल प्रताप सिंह।
We are giving you 1 week so that if you want,
जी।
you may file rejoinder also.
जी, my lord.
Mr. Sumit Kumar Singh, Land Counsel, appearing on behalf of the petitioners, has submitted that in the lead case, a counter affidavit has been, a copy of counter affidavit has been served on him only yesterday. First off, he seeks adjournment for considering the counter affidavit and filing a rejoinder if so required. First off, as requested, list this matter on Monday.
My lord. Obliged.
15, CWJC number 139.
May I please, Your Lordship? It may be passed over for the day, Your Lordship, as the senior counsel, Mr. Amit Srivastava, has to argue this matter.
As requested on behalf of the petitioner, list this matter on Friday.
Pass over for the day.
Friday?
Friday.
Yes.
16, CWJC number 14338 of 21, Sir Sayur Prasad Sharma versus President of Bihar for the petitioner Mr. Gaurav Govind for the case Mr. Arvind Issue XC4.
May it please, Your Lordship. Lord, this is a case of cancellation of PDS license.
Yes.
Lord, the order is at annexure 4 at page 27. If my Lord will see the order, Lord, the very first line. Has Your Lordship got it?
Page?
My Lord, page 27, annexure 4.
Yes.
Lord, if Your Lordship will see the order, Lord, the first line. यह अभिलेख प्रखंड आपूर्ति पदाधिकारी रामगढ़ के पत्रांक 29 दिनांक 26/4/2020 के द्वारा प्राप्त जांच प्रतिवेदन के आधार पर प्रारंभ किया जाता है. Lord, the inquiry report was submitted by the block supply officer on 26/4/2020. Lord, the supply case was instituted on 26/4/2020, and Lord, my license was also cancelled on 26/4/2020 on the same date.
What is the stage of appeal?
Lord, my appeal has also been dismissed, my Lord, at annexure 6. My Lord, is the order at page 41.
When was the show cause notice issued? Yes, my lord.
My Lord, the show cause was issued on 19/4/2020. And Lord, thereafter I submitted my show cause on 22/4/2020. My Lord, in the counter affidavit they say that after I submitted my show cause, The SDO Mohania directed the block supply officer to submit his report. The report was submitted on 26 for 2020. And my lord, on the basis of that report, the supply case number was instituted on 26 for 2020. And my lord, on 26 for 2020 itself, my PDS license came to be cancelled. No opportunity of hearing was given to me, my lord. Neither, my lord, this...
Hearing was given to you. The explanation was given, served on you on 19/4.
Yes, my lord.
You
Yes.
replied.
My lord.
What else is required?
My lord, thereafter the inquiry report, which came to be submitted on 26 for 2020.
That is not an inquiry report, that is just comments.
But my lord, on the basis of that report, my lord, I have initiated this supply case. And if my lord may kindly...
For this assistance only, my lord.
And if
Where
my
is the
lord...
notice?
Annexure 1, my lord.
Annexure, my lord.
At page 21, my lord.
Please let me say.
My lord, Annexure 1, my lord, at page 21.
In your appeal, where have you raised this issue? That inquiry report 26/4 was not given to you, or due opportunity was not given after that?
My lord, in my appeal, my lord, I...
Which paragraph, please?
My lord.
We are trying to see that.
My lord, in the grounds, my lord, at page 33. My lord, third ground. For that, the BSO Ramgarh has submitted its report on 26 for 2020, and on the same day, the SDO Mohania has cancelled the license of the appellant without giving opportunity of being heard, of being heard to.
Yes, state.
My lord. My lord, the annexure, can you see annexure 1, my lord?
Annexure?
That is the show cause notice. Annexure 1, my lord.
So forget annexure 1. Come to the impute order.
My lord. My lord, one, this is लिखने में जो कुछ गड़बड़ देखा जाए, ये 22 तारीख को ये अपना रिप्लाई सबमिट किया और रिप्लाई में क्या दिए देख लिया जाए, केवल डिनायल, एक लाइन का डिनायल कि इस एप्लीकेशन आप देयर आफ्टर पेज नंबर 22 and thereafter, my lord, the SDO is taking assistance of the block supply officer, my lord, कि इस 22 पेज 20 पे जो उनका रिप्लाई है उसके बारे में and the block of supply for the assistance only, my lord, to whether the allegation, whether the reply submitted or petition is true or not. Thereafter he submitted his report, that is for the assistance only. Inquiry was conducted on 19th 4/20, my lord. Thereafter, on the basis of the report of the inquiry, joint team of the by the inquiry made by the joint team, my lord. And thereafter, he filed so-called notice was issued. And thereafter, on the reply, my lord, only he is taking assistance of block supply officer for the veracity of the so-called reply, my lord.
Sir, your decision is based on a document.
My lord.
Your decision may not be totally best, but it takes into account a report of the block development officer. He had a right to know what was there in the report. He had a right to know, even for the purpose of preferring appeal against that order.
But my lord,
Have you brought that on record?
In the reply, my lord, he has stated nothing.
He
Only
has-
denied.
Where is this notice?
My lord,
Where is the notice?
notice page 21, annexure 1, my lord.
साक्ष्य के साथ तो उसको देना चाहिए। देखिए क्या कहते हैं, जबकि हमने वितरण किया कुछ नहीं दिया।
You see Annexure 1?
Milord.
Opportunity was given to you to submit your response along with the evidence. You did not produce the register before them. When the opportunity was given to you, why did you not produce the register in your response? Annexure 2 also. It is a one-line response which says that I have distributed based on POS machine.
If
So
my lord,
can you, such a person be permitted to take advantage of natural justice? It is not a straitjacket formula that it has to be applied everywhere. What is the prejudice? You were given opportunity, you didn't submit the register.
my lord, that is my submission, my lord. Thereafter, my lord, the block supply officer has taken the statement of 20 consumers who have complained against me.
That is all of 26/4 on the day on which the order was passed.
My lord.
This is much prior thereto on 22/4. You did not avail the opportunity. A person who has not availed the opportunity under granted under the principles of natural justice, can he be permitted to complain that
if my lord may kindly
violation of violation of principles of natural justice?
If my lord may kindly see Annexure 1, my lord.
Yes.
My lord, it only
Please
says.
read it. Please read it. आदेश दिया जाता है।
उसके पहले हुजूर ऊपर देखा जाएगा।
पढ़िए।
उपयुक्त विषयक दिनांक 19/4/2020 को प्रखंड विकास पदाधिकारी, अंचलाधिकारी एवं प्रखंड आपूर्ति पदाधिकारी रामगढ़ द्वारा आपकी दुकान की जांच के क्रम में आपकी दुकान से संबद्ध उपभोक्ताओं द्वारा आपके वितरण में व्यवहार की काफी शिकायत की गई तथा मार्च 2020 में के वितरण में अनियमितता की शिकायत की गई। Lord, who were the consumers who had made a complaint?
Please complete it.
उपभोक्ताओं से प्राप्त शिकायत के आलोक में आपकी दुकान सील कर दी गई है। आपके द्वारा मार्च 2020 का वितरण पंजी प्रस्तुत नहीं किया गया। आपका यह कृत्य सार्वजनिक वितरण प्रणाली नियंत्रण आदेश के प्रावधानों का उल्लंघन है तथा यह आपकी कर्तव्यहीनता एवं लापरवाही का भी घोतक है। आदेश दिया जाता है कि इस पत्र प्राप्ति के 24 घंटे के अंदर उपरोक्त बढ़ती गई अनियमितताओं के लिए।
Did you ever produce the Vitran Panji of March 2020? Mr. Counsel, all of us have to be very alive to the fact that these were very trying times and distribution of essential commodity was of great significance in those times. So you have to argue keeping that in mind also. This is of March, April 2020. You have never produced. So now can you be permitted to take advantage of this so-called lapse?
My lord, my instruction is that nowadays the distribution is made through POS machine. Yes. And my lord, the department has all the technology.
So did you say that the preparation of register has been dispensed with?
My lord, in the appeal, my lord.
POS machine means point of sale machine. That is a GPS enabled machine linked to the satellite. Does that new policy contemplate dispensing with the maintenance of register?
Lord, in my appeal, my lord, I have stated that.
That no register is not required to be maintained. Show us if that is the case, then we may consider it otherwise also.
And why appeal? Your reply?
My lord.
Your reply. Have you stated in your reply that yes?
Not
yes,
in my
register
reply.
Register could not be produced then?
No, my lord. In my appeal, my lord, I have stated that.
Why should you say something in appeal which you did not say in your reply?
My lord, since because my lord, the
appellate authority was required to decide on the basis of what was there before the appellate authority. Your stand.
My lord, since the
before the original court.
My lord, since the show cause was very vague.
Show cause was not vague.
It does not.
Show cause may be vague for other purposes. but not for the purpose of non-production by you of the register. That was not done. That is an admitted fact. So you can have only two stands, either that you are not required to maintain this, or your having POS distribution through POS machine was sufficient.
But, my lord, since, my lord, the cancellation is on the basis of that inquiry report, the supply case, my lord, has been instituted on the basis of that report of the block supply officer, my lord.
Forget supply case. There is supply case. The question is of cancellation of your license by the licensing authority in accordance with the provisions under the rules order. Before that, notice was given to you. You do not deny. It is specific allegation that your distribution register was not presented. You did not say that you rather maintained, but yes, and that is the finding recorded in the order of cancellation.
Lord, if my lord may permit me, my lord, I may quote Rule 27(2), my lord, of the Bihar Targeted Public Distribution System Control Order 2016. My lord, that says, no order of cancellation of a license shall be made until the licensee has been given sufficient opportunity to state his case against the proposal of cancellation of his license. My lord, on 26/4/2020, they initiate a case.
No, 26. The notice is annexure 1. Why are you going to initiation? This is the so-called notice.
That is the so-called notice.
Then, that's all. No question of initiation. Initially, we were also of the, rather you created this impression that it was initiated on 26, order passed on 26, so-called notice was given on 26, you replied on 26, and the final order was passed on 26. That would have been a different matter. But here the case is different. You were noticed on 19/4, you replied to that, you did not take any plea that the time allowed to you is not sufficient. Then you do not deny that the register was there with you, which you could not produce.
And even if the complaint by the beneficiaries is to be ignored, it is the terms of the license to maintain register and failure to do so itself is per se sufficient for cancellation of your license. And that finding has been recorded. You have never produced any register. That is one of the grounds available for cancellation, non-maintenance of register.
And my lord, 14(4) of the rule, my lord, says the licenses shall maintain records of the ration card holders as is stock register, issue of sale register in the format prescribed for the time to time by the administrative department, and it shall also be include electronic.
And why did you not prefer revision against the order? There is provision.
Lord, there is a provision, my lord, of filing a revision.
Then?
That liberty, my lord, may be granted to prefer. That liberty, my lord, may be granted to file a revision.
That liberty we can grant, but if you seek, then only. Otherwise.
You want to go for revision. Why didn't you go within the time specified?
But since, my lord, I was under the impression that since, my lord, the order has been passed in violation of the rules, and, my lord, the report was submitted on 26/4/2020, and the order was also passed on 26/4/2020. So, my lord, we preferred a writ application before this honorable court.
The petitioner's license to run a PTA shop under Bihar Targeted Public Distribution System, bracketed order 2016, has been cancelled by an order dated 26/4/2020, which the petitioner has assailed in the present writ application. His appeal has also been dismissed by the District Magistrate Kaimur cum Appellate Authority by an order dated 18/3/2021, which is also under challenge in this application. So stop. And counsel for the petitioner, after some argument, seeks permission to withdraw this application. तो उसको करना है. This is an admitted fact position that 2016 order provides for a revision against the order of the appellate authority, which the petitioner has not availed. Stop. Next. After some argument, learned counsel for the petitioner seeks permission to withdraw this application with her liberty to prefer a revision petition before the revisional authority. Stop. Considering the facts and circumstances, this application is permitted to be withdrawn and stands disposed of with her liberty to the petitioner to prefer a revision petition before the appropriate authority.
TWJC number 10054 of 15, Ashok Kumar Singh versus the Bihar Police Board of Investigation for the petitioner Mr. Hasika Chatterjee, Mr. Samir Kumar Sinha, for the other side Mr. Ganpati Trivedi, Mr. Sanjay Kumar Singh, Mr. Vinod Kumar.
My lord, in this case I pray for a pass over me.
Pass over this one, but then let it come on Monday, my lord. Let it come on Monday.
Monday?
Yes.
So, madam, every morning we come across at least 2-3 mentioning slips sent by you.
Yes.
Sent by under your signature. Not in this case. As jointly requested this case on Monday.
CWJC number 18043 of 19, Srimati Krishna Devi versus the State of Bihar for the petitioner Mr. Amrendra Narayan, Mr. Deepak Kumar, for the state Mr. Mohammed Nadeem Siraj,
55. Yes. My lord, the petitioner is the elect Pramukh of Kalyanpur Block Lordship. Now the period of the Pramukh, although has expired, but now she is continuing, and the petitioner has been filed alleging grievances against certain irregularities in the block, and her grievance was against the secretary, the BDO. Under the Panchayat Samiti, the BDO have...
You are Pramukh?
I am Pramukh Lordship.
What grievance do you have?
A grievance that in spite of repeated requests, the Indira Awas scheme and other schemes were not brought in the agenda by the BDO. She has tried her best and requested the collector and other officials that bring those things before the Panchayat Samiti for necessary verification of the complaints and for examining everything, Lordship. The Pramukh, which has been created under the local self-government, has the authority to examine such things, Lordship. But the respondent number 8 and 9, who happens to be the previous BDO secretary and the present, never brought these things. And the Panchayat Samiti has occasion to hear complaints of the different persons of the locality, Lordship. On this pretext, when she approached the collector and other authorities and she could not get any relief, the authorities sent her to public grievance redressal cell. She also approached that orders are there, Lordship. Lastly, she has taken the rescue of this before the Honorable Court, Lordship. Now the counter affidavit has been filed by the earlier the counter petition was filed by the BDO against which the complaint was there, Lordship. Thereafter, the SDO has filed of the counter affidavit, reiterating the same facts which has come before from the mouth of the person against which the complaint was, Lordship. My submission would be that, Lordship, that the grievances raised in the petition are not related to the personal level of the Pramukh, anything. A high-level inquiry should be ordered, Lordship, and I should be represented. Or, in alternative, Lordship, since the Panchayat Samiti has defunct, Lordship, and again I have selected, I have contested the election, I have again. So, if the Lordship adjourn this matter after to be taken up after 15th January, there will be a new Panchayat Samiti, and then the matter can be referred to the Panchayat Samiti. Otherwise, the matter should be examined by the higher level committees, Lordship, in any secretary level, and I may be permitted to represent their Lordship. For the ends of justice, because the matter relates to Indira Awas and the distributions of the various schemes of the Panchayat, Lordship.
You are Pramukh. You were
Lordship.
Pramukh.
Yes, Lordship.
You are likely to become Pramukh again.
No, I am not. I have contested elections, and this time also I have. And what happened, I will not say that. Pramukh is selected after the Panchayat Samiti members vote, select them as a Pramukh. This is no direct election for the post of Pramukh. In the Panchayat Samiti, again, I have contested and I have been elected, Lordship. So what will happen, I don't say. But in the Panchayat Samiti, I shall be there. So I as a Panchayat Samiti member, I can set for proposal for bringing those things in the agenda of the Panchayat Samiti so that the things could be examined properly. Otherwise, it will, if the Lordship sends this matter to any higher authority to be examined, then the petitioner will have no grievance because any higher authorities will examine.
Did you ever
complain
to anyone that the BDO is not cooperating?
Yes, I have made so many complaints. The answers are there, Lordship.
To which authorities?
To the secretary level, collector, and all officials, Lordship. And they sent me to the public grievance relations cell, and there also the appeal authorities. All records are there, Lordship. And none had bothered to respond. Even filing of this complaint, this is a serious matter. The collector has not bothered to file a statement before this honorable court.
You availed remedy under the public grievance redressal?
No, that is not there. But they sent me to go there, and the poor lady went there.
No order was passed.
Order was passed, Lordship. The order is there in the record.
Then that is appealable under the
appeal. The appeals have also she also preferred appeal.
And that has also
and that's also said that these matters cannot be considered before the appellate authority. And I always filed as a Pramukh, not as an individual. And my grievance were against the issues for the public issues, for which I am the custodian. I have to examine these things.
And respondent number 9 is still working as BDO?
No, the respondent 8 तो transfer उनका हो गया हुजूर, और 9 थे अभी काम में.
9 का ट्रांसफर होगा, 8 का कैसे? 8 तो होंगे ही वहाँ.
हाँ, 8 थी, 8 का 9 का ये हो गया है ट्रांसफर. 8 थी.
Yes. Let us come to your relief number 1.
Dear Lords. The relief number 1 is, Lordship, that a to make inquiry in the mass level illegalities and irregularities committed in allotment and disbursement of Pradhan
Mass
Mantri
level
Awas.
illegality, where is that?
Illegality is that, Lordship, that the petitioner has complaints of the different persons of the
Where is that? Panchayat Raj Act.
Annexure 3, page 24 may be seen, Lordship.
You are trying to blackmail respond number 9. Sir, so what kind of this? You are relying on Annexure 3?
Lordship.
What is there in Annexure 3?
प्रखंड भ्रमण के क्रम में आम जनताओं से ऐसी शिकायत मिली है कि इंदिरा आवास सहायक द्वारा किसी अन्य व्यक्ति को जानकारी दी जाती है तथा लाभुक को जानकारी नहीं दी जाती है और इंदिरा आवास की सूची बनाई गई है या जनप्रतिनिधि द्वारा सूची में गड़बड़ी का आवेदन मिला है, जबकि सरकार का निर्देश है कि लाभुक के घर पर जाकर उनसे संपर्क कर
Irregularities, illegalities, then respond number 9, and then so many things are there against respond number 9. This is not the way.
There is no verifiable material. It is just saying that समीक्षात्मक report कीजिए of all these issues. To what avail?
And then seeking a direction to respondent number 9 to place the documents before Panchayat Samiti.
Lordship.
So this is what the High Court will do.
Lord, kindly see the Annexure 3, Lord, and relief number 3, Lordship. Relief number 4.
Is there any vigilance committee constituted under section 10?
No.
Did you seek constitution of vigilance committee?
No.
Why? That is the only check which appears to be there in the act. There has to be a vigilance committee in the panchayat which will look into these things. Instead of that, you are holding the officials to ransom.
That has not been done. That
was required to be done. You are a permit. Why didn't you get the vigilance committee constituted?
Only the petitions has been sent to the different authorities alleging various things, Lordship, and in the counter.
That also is devoid of any substance. Just saying that irregularities.
So there is.
We understand you cannot improve your case, but because that is the material.
That is their lordship. The Pramukh has sent only representations to different authorities, lordship. As your lordship, please, as lordship. These are the situations. They themselves admit that they have not placed the records, and in the counter affidavit, they have stated that it is not required in law to place those records before the Panchayat Samiti. This is a very serious thing, lordship, and to be settled by this court, lordship, that if such things happen, then the meaning of the Panchayat Samiti and the purpose of the others will also take liberty of
It's
this.
very difficult, Mr. Narayan, to say who is defeating what. If there is any list before us, we have a duty to decide. We have. So you are making your submissions. You make your submissions. We will answer that. Otherwise, if you want to pursue after reconstitution of Panchayat Samiti, you may do. We don't know.
As your lordship pleases.
Huh?
As your lordship pleases.
No, this is up to you. Mr. Narayan, we will just see your relief which you have sought. We will see your pleadings. And on the basis of pleadings, if we are satisfied that something is to be seen in the pleadings of the other side, we will see that also. And then we will decide. You have not been able to make out any case on the basis of what is there in the writ petition. This is our tentative opinion.
The writ opinions.
There is no verifiable material on the basis of which any order which you are seeking can be issued.
Then, my lord, an adjournment may be made. The others.
Sorry, no adjournment. No adjournment matters. Pending since the petitioner claims to be elected Pramukh. Bracketed now erstwhile of Kalyanpur block
under Samastipur district.
Kalyanpur block under Samastipur district. She is seeking a direction to the respondents to cause an inquiry into large scale illegalities and irregularities committed in allotment and disbursement of Pradhan Mantri Awas Fund and toilet funds in the said block. So stop. She is also seeking a direction to the block development officer to put entire list of allotment and distribution of Pradhan Mantri Awas Yojana Shauchalaya Fund with the list of beneficiaries before Panchayat, Block Panchayat Samiti. There are two other reliefs which the petitioner is seeking, as is evident from paragraph 1 of 3 other reliefs. Petitioner is seeking. No, stop. Next. On close reading of the writ petition, it appears that the petitioner's main grievance was against the then block development officer of the bank who has, of the block, who has admittedly been transferred and is no more holding the post of block development officer of the said block. So stop. Further, the Panchayat election of Panchayats in question is election have now concluded. So stop. Next. Except for vague allegations of illegality and irregularities committed by respondent number 8, comma, there is no verifiable material brought on record by the petitioner so as to make out a case for this court's interference in a proceeding under Article 226 of the Constitution of India. Full stop. Next. Considering the above, this application is disposed of with an observation that the petitioner shall be at liberty to raise the issue after a reconstitution of the Panchayat Samiti.
In this
case number 2635 of 20 Krishna B versus the state of Bihar for the petitioner Mr. Mahasweta Chatterjee, Mr. Ram Nivas Mishra for the state Mr. Sushil Kumar DP20 and Mr. Mukesh Kumar.
Eighteen and 19. आराम दिखाई नहीं पड़ता है, दिखाई नहीं ना पड़ता है। ऐसा नहीं करने से दिखाई नहीं पड़ता। ये जो पट्टी है In this case, again, my lord, I will pray that both the cases may be taken up after Christmas holidays. But since there is some I have received instruction today itself that there is some subsequent development in this case. I want to bring all these on record. That is why I pray that both the cases may come after Christmas holidays, my lord.
So far, first case is concerned, my lord, that has become infructuous.
No, my lord. Then I will start argument. Both the cases are interrelated. The second case is the important case, that is dispute with regard to the number of the membership by which the state election authority has rejected the prayer of the petitioner to remove the names of some of the names which have been included by the election officer, has not been submitted by the society. In this regard, there is some development perhaps. Madam, that is the instruction I have received today, my lord.
Madam, please help us in reducing the volume. If first writ petition has become infructuous, then we can dispose this application off as having become infructuous. And second case we will take up.
No, my lord, infructuous nahi hai, isliye the election is to be held on the basis of the voter list, and the dispute with regard to the voter list is in second case, my lord. And once the election was held, thereafter that election was challenged. That election has been set aside under section 48 of the Act, my lord. Thereafter, the petition was filed before that has been rejected. Again, a petition has been filed by one elected secretary whose election has been set aside, my lord, and that petition was heard subsequently, and thereafter subject to the result of this second case. Therefore, both the cases may be heard together. Let me file Supplementary affidavit, my lord.
What is your submission in the first case?
First case में सब यह है my lord, elected for a direction to conduct the election of the society, my lord.
No, that is based on a particular membership which you claim. That
Now, my
election
lord,
be conducted with so many number of members.
Yes, my lord.
So
What
how many
happened?
number of members are to be there? Who is to decide this?
My lord, the rule 21 says that it is the society which is to submit the voter list.
Yes, before.
And the society submitted the voter list of 525.
Before which authority?
Elections, sir. After notification of the election.
And yet that is not open to dispute.
And when the final voter list is published, instead of 525 submitted by the society, more than.
Lord, may I point out, on 28th of
So,
June.
madam.
Yes, my lord.
In the first case, you don't have to bring on record any new material?
First case is dependent on the second case, my lord. Therefore, my prayer is that.
Your submission was that you want to bring on record certain fresh materials because of subsequent developments. This is your submission?
Subsequent development को record पर लाना चाहते हैं.
Yes, huh?
You want to bring on record certain new materials in view of subsequent developments.
Yes, today I have received only instruction. Perhaps there is some subsequent.
Please let us complete, madam. You want to please take your seat.
I am feeling difficulty, my lord. That is why I can hear your lordship also.
You want to record certain new materials in view of subsequent developments?
Yes.
In the second case, we understand that decision in your submission is that decision in the second case will depend on decision in the first case.
Yes.
But those subsequent developments are in relation to the second case. First case pleadings are over, everything is over. Let us see what is there in the first case.
Both cases are interrelated, my lord. And there is a recent, Komal Paswan, the election has been set aside. He is saying because that election has been conducted thereafter in the year 17, an election was challenged and set aside. And thereafter, Komal Paswan, the elected secretary, filed a petition before the state election authority that the election may be conducted on the basis of the 865 members as according to the final voter list submitted by the election officer. My lord, I have filed the first case for conducting the election, and second case is that the election should be conducted on the basis of.
All right, we are interjecting. First case you filed for holding of election.
Yes, yes.
Whether election has been held?
No.
No. All right. So let us see why were you required to file a second case?
Well, unless and until the second case is decided, no election can be conducted because it is with regard to the dispute of total membership.
And without deciding first case, election can be held. Election cannot be held without deciding second
without
case.
Deciding the second petition.
But election can be held without deciding first case.
How can the election, I am putting a question to myself, my lord, how can the election be held when the final voter list is in dispute?
Let us begin with the first case. Let us see whether there is any material or not in the first case.
First case is for direction. First case is for a direction to the state election.
Let us see why the first case should remain pending. We don't know.
My Lord, in the first case, my prayer is to
So your prayer is not to conduct election on the basis of voter list.
Krishna Bin. In the first case, my Lord, in CWJC number 2635, the prayer is for a direction to the Bihar State Election Authority to conduct the election of Shivsagar Prakhand Matsyavi Sahayok Samiti Limited on the basis of the voter list submitted by the district cooperative officer by his letter number so and so, and that is the voter list submitted by the society.
Yes.
And the society removed 55 and 435 members in 2 meetings which were approved in Amsabha. I have annexed all the documents which were approved in Amsabha, and both the resolutions were never challenged. So the matter of removal has reached its finality, and when the election was notified, as per Rule 21I, the society submitted the voter list to the election officer of containing the name of 525 members. Thereafter, the petitioner heard that the election officer is going to add some of the names of the members. Therefore, he again filed a petition before the election officer. That was not done. Finally, the voter list was published containing the name of the removed member of 865. Therefore, he filed a petition before the State Chief Election Officer, Bihar State Election Authority, my Lord. And after hearing the parties, my petition has been rejected. Therefore, in this case, my prayer is that and my Lord, after the petitioner submitted the election list and objections were filed, then the BDO, the election officer, sought guideline from the district cooperative officer, and district cooperative officer gave him a letter that you should publish the final voter list on the basis of the list submitted by the society. In spite of that, without any...
Where is the provision for preparation of voter list? Who is
yes,
to
yes,
decide?
well, Article 21.
Who
Rule
is to
21.
decide? Who is to decide when there is any dispute in respect of the voter list?
Here in this case, my Lord.
It is basically membership dispute.
No, my Lord. No, my Lord. It is not a dispute. But that dispute has never been raised, my Lord.
Please, we will not stop you from making your submission. Please sit down, Mr. Counsel. Please make your submission. Madam.
Yes. My Lord, section 48 is dispute. If anybody is aggrieved by the decision of the managing committee, then he can file a dispute case before the registrar under section 48 of the Act.
Yes.
Here my submission is that in 2 meetings, the majority of the managing committee removed 55 and 435 members after issuing notice or even after publication in the newspaper, and no dispute, those decisions were never challenged by any corner, by any party. Therefore, my submission is that their removal by the majority of the managing committee under bylaws number 9 has reached its finality. Let me place the facts, my Lord. Kindly see the facts. And thereafter, their name.
according to you, madam,
Ji.
the High Court will decide which should be the voter list, or who should be the voters.
No, I am on settled principle of law, my lord. I am on settled principle. High Court has already decided. That is reported in 2010 PLJR.
What is that principle?
Principle is that the election officer has no right to add any name. It is the society which is to submit the voter list. That is why, my lord, I was requesting your lordship to allow me to place to give your lordship the facts. Then I can the picture will be clear, my lord. My lord, the election was held, and the secretary and the some of his groups started working against the interest of the society.
Election is held under which provision?
Yes. I. My lord, to rule 21I and J.
Of what?
Bihar Cooperative Societies Rule 1959.
(21)
21 I and J.
Bihar Cooperative Societies Rules 1959.
Ji.
Rule 21.
Ji.
Proceedings at general meetings.
21. My lord, 21I says about the submission of the voter list, and 21J speaks about...
We are not getting it. Bihar Cooperative Societies Rules 1959.
59. 59.
Yes. Capital I you should have said.
Rule 21. 21D speaks that election officer should be appointed. 21 ही election है, Rule 21.
Who is election officer?
Video.
According to you, how many members are there in this society?
According to me, I submitted 525 members.
And according to the other side, how many members are?
865, my lord.
865. Now please come to section 48 of the Act.
Yes.
Second explanation.
Yes, my lord.
Second explanation. Please see the second explanation to section 48 of the Cooperative Societies Act.
Yes,
please read
yes.
it.
Yes, my lord. I derive my submission from that section.
Madam, please read it.
Yes, I am reading it.
Yes.
I got it.
Please place it.
Yes, my lord. Second explanation is that the question whether a person is or was a member of a registered society or not shall be a dispute within the meaning of this subsection.
Then?
Yes, my lord. Yes, my
what
lord.
yes?
Then kindly bear with me. Kindly come to bylaws number
That
9.
is a dispute under section 48.
Yes, my
And
lord.
who is to determine disputes under section 48?
Registrar.
Registrar Cooperative Society.
Registrar Cooperative.
And what are you doing here?
Therefore, my submission for your lordship's consideration is that it is it is in exercise of the power given to the society. Their members were removed, and only requirement is to approve the removal, the resolution passed by the managing committee in an Am Sabha.
Madam, the question is of resolution of dispute. It's no question what decision was taken in Am Sabha and how wrong the decision was taken or how right the decision was taken. The question is how the dispute is to be resolved. That is the only question.
The question, my submission will be for in reply that there is no dispute. Isliye there is no dispute. After the resolution passed by the majority of the managing committee removing the members, and after it is approved by the in the Am Sabha, the aggrieved party was required to file a case under section 48 of the Act, and none of them has filed any case according to second explanation of section 48. Thereafter, none of the aggrieved party who were removed, they approached any before the registrar. Therefore, their removal has become final. Therefore, I am submitting before your lordship that there is no dispute. Registrar, had they been approached, the registrar could have decided that the removal is bad or not, they are members or not. Nobody has approached the registrar. It is the power of the managing committee to remove. Therefore, I was trying to show before your lordship the power vested to the managing committee under bylaws number 9, and after following the procedure, they were removed.
Yes.
And as far as the question of being the first case infractuous, my lord, the same submission was made earlier also, and there is an order by dated 5/11/20 also, my lord.
Five 11/20 in which case?
First case, 9153. अब हमको दीजिए वाला कोमल भाषण और ऑर्डर है कोमल भाषण
What is Annexure 45?
45 देखिए तो
The final publication of the voter list is not correct as per your claim in Annexure 45.
Yes.
So what is that dispute is to be decided by which authority? The dispute which you have raised in Annexure 45, that the voter list is not correct, that is to be decided by which authority?
My lord, I filed a petition before the chief election officer.
Why did you, when you know that is a dispute which is to be decided by the registrar, cooperative, why did you move
No,
the?
according in that, my lord, in reply to that, my lord, my humble submission will be: it is not the society which should approach the registrar. The society is vested with the power. If the majority of the managing committee pass the resolution, that becomes final. And if any member is aggrieved by the resolution passed by the managing committee, it becomes a dispute within the meaning of section 48
You
of
are
the...
aggrieved, it is apparent from Annexure 45, you are aggrieved, read Annexure 45.
Yes, being aggrieved, because
Then
I
you
am
go
on
before the
settled
registrar
principle.
cooperative
My
society.
lord, I am on settled principle of law that since the election officer, perhaps I am not clear, my lord. Allow me to clear the position, my lord. Perhaps I am not able to make it clear before your lordship.
No, no. We may not be able to appreciate.
I am not able to
All right.
clear.
Yes, please make your submissions.
Yes, my lord. Submission is that the petitioner society...
All right, tomorrow.
Tomorrow. I will make it clear. And as far as, my lord, this serial number 17 is concerned, your lordship told me that in that case, my lord, I didn't take time. I just accommodated.
On the above consideration and observation, this court would hold that no case has been made out by the petitioner for interference with the terms of NIT within the settled parameters of judicial review in respect of terms of NIT and contract matters. The petition is devoid of merit and the same is dismissed.
Highly obliged, Lordship.
I agree.
Obliged, Lordship.
लंच के वक्त
आप ये दे दें जजमेंट वाले
After Monday. After Monday.
सारा इन्हीं का है सर, ये सुमित जी का ही है।
लेकिन एक दिन कॉल हुआ है सब कुछ।
सुमित जी ही थे सर ना?
हाँ, ईमेल से किए थे ना। कॉल हुआ एक दिन हम आए थे, और संजय से मेरा केस था पनवार, चले गए इधर 4-5 दिन पहले। पेशकार साहब, एक केस हम लोग मेंशन किए थे, संजोग से केस कॉल आउट भी हुआ था शायद। उस दिन केस हमारा था उस दिन पनवार साहब के यहाँ। तो हम ये जानना चाह रहे हैं कि क्या हुआ हम लोग का केस में। एक CWJC नंबर था 17945 2021। 17945 2021 बता दे जी।
अच्छा, इसी में को बोला
साढ़े 3 बजे
3 बजे।
जजमेंट वाले में सीरियल 4 का सीरियल 4
तो क्या हम भी 3:30 बजे आए क्या? हम भी 3:30
जो भी है उनका अलग कर दीजिए 11 डिस्प्ले करने के लिए बोल रहा
मनोज जी छुट्टी पर हैं क्या राकेश जी? मनोज जी छुट्टी पर हैं?
सब हटा रहे हैं। हाँ हाँ
अच्छा लीजिए। हाँ
क्या बोल रहे हैं आप? क्या करना पड़ेगा?
Lord, I have to file the entire deposition of the three witnesses, my Lord.
Just a minute. Call for a report from the court below as regards present stage of the trial arising out of Munger Kotwali Purbasarai PS case number 555 of 2018.
Though, my Lord, 3 months' time have been given, was given to the prosecution to conclude the trial.
4 weeks.
Item number 3, file not available. Item number 4, criminal miscellaneous 79396 of 19 towards Digvijay Singh.
Yes. Who is for the state? No one appears on behalf of the petitioner. List this case on Wednesday.
Item number 5, criminal miscellaneous 80198 of 19 Ravindra Kumar.
There is no representation on behalf of the petitioner. This application is dismissed for default.
Serial number 6, Mr. Sanjay Kumar, number 7, Mr. Vignesh Kumar Pandey.
Met, please. It is restoration petition, my lord, for restoring the file of anticipatory bail to its original file, my lord.
Why default?
Lord, the
You are
file
not
for
present.
main petition is with regard to anticipatory bail of the petitioner.
Allowed.
Obliged.
Serial number 7, Mr. Vipin Kumar Singh, Mr. Ehsas Manikan.
Yes. No one appears on behalf of the petitioner. List this case on next Wednesday.
8, serial number 8.
May I please, Lords?
Yes.
Lord, it is cancellation of bail, my Lord, granted to the petitioner, opposite party.
Yes.
Lord, on the previous occasion when I had appeared, Your Lordship, observation of Your Lordship was, my Lord, that I ought to have challenged it before the Supreme Court. On the Lord premise, it seems to me, my Lord, that grant of bail is a rule, an exception, cancellation is exception. And Your Lordship has been pleased to direct me, my Lord, to address on the point of as to whether on merit I can challenge it or not. Perhaps that was your Lordship's observation. My Lord, I had on the previous occasion, my Lord, I had given the books, my Lord, two books your Lordship would be relevant. 2008 volume 5 SCC 74.
Yes.
2008 volume 5 SCC page 74. Paragraph, my Lord, 23, 25, 26.
Yes.
गलत लिखा गया है मैम, क्या है? I'm sorry, Lordship. It is 66, Lordship. Page 66.
Page 66.
जी.
Yes.
Paragraph 23, Lordship will find at page 7. May I, Lord, before that, may I refer to facts?
Yes.
Yes. मैम इसको लगा दीजिएगा. If your Lordship, Lord, will see, Lord, the order granting bail. It is order dated 3/6/20 at the end of the brief. Milord, at page 2, Milord, it would be, Milord, second paragraph after 3-4 lines from the top. A raiding team was subsequently constituted after verification of the allegation made by the complainant. From the post-trap memorandum, it appears that the petitioner and Pappu Srivastava, a co-accused, were apprehended by the vigilance reliefs red-handed. And thereafter, Milord, the argument has been recorded, Milord. Learned counsel appearing on behalf of the petitioner has submitted, referring to the post-trap memorandum, that admittedly no money was recovered from the petitioner's possession. Allegedly, during the trap, the vigilance personnel recovered from the possession of co-accused Pappu Srivastava a sum of rupees 10,000, which the complainant had given as bribe. It is mentioned in the post-trap memorandum that the complainant had told the vigilance officials that the money was taken by the petitioner, which was handed over by him to co-accused Pappu Srivastava. In the background of the aforesaid allegation, the counsel for the petitioner has submitted that since there is no recovery of any incriminating material from the petitioner's possession, he reserves grant of bail as is in custody since 13 to 20. Considering the submission that the said bribe money recovered from the possession of co-accused Pappu Srivastava, this application is allowed and thereafter bail. My Lord, if your Lordship will see, my Lord, Pappu Srivastava order, your Lordship 20974 of 20. It is passed by your Lordship, my Lord, dated 19/8/20. Wherein, my Lord,
where is that?
Records have been summoned, your Lordship, on the previous date. That's why I was referring to the records. In that case, my Lord, it is criminal miscellaneous 20974 of 20.
Not required, Mr. Ajay Kumar.
Yes. Why it is
Once
required?
bail has been granted, if he is not appearing, then the matter is different. His bill can be cancelled. Otherwise,
My Lord, if your Lordship will see, my Lord,
rightly
that
or wrongly, Mr. Anjani Kumar, once bail has been allowed,
I know, my Lord, I am, my Lord, trying to make submissions in exception clause, my Lord. I am conscious of all these things, Lordship. But when I was appearing, my Lord, in that case, my Lord, while I was making submissions, that's why your Lordships observed, my Lord, that if you are agreed, then file cancellation. That led to filing of cancellation. In consonance with your Lordship's observation. If your Lordship will see, my Lord, kindly see, for a moment, your Lordship, Pappu Srivastava order, Lordship, at page 2 in the middle. In the first part, my Lord, the FIR has been quoted. Thereafter, Learned counsel appearing on behalf of the petitioner has submitted that the allegation of demand of bribe money, negotiation thereof and its receiving is against co-accused Sanjay Srivastava. That's got it.
Yes, yes.
Sanjay Kumar Srivastava. The petitioner has been implicated only because said Sanjay Kumar Srivastava had handed over the said amount to the petitioner.
Yes.
Whereafter he was apprehended, the petitioner is delivered so and so.
So these are allegations.
Lord, in nutshell, the story, Lord, of catching red-handed is that it is this gentleman, the opposite party number 2, Lord, who has, Lord, accepted the bribe and handed over to Pappu Srivastava. And that's why nothing came to be recovered, but his hands, Lord, were washed in the solution and all these things had taken place. And it is this person, Lord, who is responsible for commission of, Lord, all the illegal acts. He is the authority. And that's why, Lord, since on merit, Lord, your Lordship was please to direct me kindly for a moment, Lord, whatever is the result. यही पे है मैम 8 वाला दीजिए ना. Kindly for a moment, your Lordship. Para 23. I was referring to, Lord, 2008, volume 5, SCC, page 66, and the relevant page would be, Lord, page 74. Paragraph 23, 25, and 26. Even though, may I read, Lordship?
Yes.
I am reading at page 74, paragraph 23. Even though the reappreciation of the evidence as done by the court, granting bail is to be avoided, the court dealing with an application for cancellation of bail under section 439(2) can consider whether irrelevant materials were taken into consideration. That is so because it is not known as to what extent the irrelevant materials weighed with the court for accepting the prayer for bail. Then kindly come to 25. The perversity as highlighted in Puran case can also flow from the fact that, as noted above, irrelevant materials have been taken into consideration, adding vulnerability to the order granting bail. The relevant materials should be of a substantial nature and not of trivial nature. In the instant case, the trial court seems to have been swayed by the fact that Sohrabuddin had steady reputation and criminal antecedent. That was not certainly a factor which was to be considered while granting bail. It was nature of the acts which ought to have been considered. I would be emphasizing this, Lords. By way of illustration, it can be said that the accused cannot take a plea while applying for bail. That person whom he killed was a hardened criminal. That certainly is not a factor which can be taken into account. Thereafter, Milord, para 26, another significant factor which is highlighted by the state before the High Court was that an FIR allegedly was filed to divert attention, so and so. Milord, only by reading this, Milord, at the cost of repetition, Milord, extract of para 25, that was not certainly a factor which was to be considered while granting bail. It was nature of the acts which ought to have been considered. These 3 lines, Lords. And 2011, volume 6, SCC, Milord.
Yes.
Page number 189, Prakash Kadam and others, Lordship. Paragraph 17, 18, and 19, Lordship.
Yes.
Para 17, Your Lordship, at page 195. It was contended by learned counsel for the appellant before us, and it was also contended before the High Court that the consideration for cancellation of bail are different from consideration for grant of bail, why so and so, so and so. However, we are of the opinion that is not an absolute rule. This I want to emphasize. And it will depend on the facts and circumstances of the case. That's why merit is open to be addressed, my Lord, in a cancellation of bail application.
Cancellation of bail application by a higher court. So all these 2 decisions are consideration by a higher court of grant of bail.
If you kindly see, my Lord, para 17.
Yes, yes.
It was contended by learned counsel for the appellant before us, and it was also contended before the High Court.
Yes.
Same contention was raised before the High Court, which was being made before
Yes,
the Honorable Supreme Court.
Yes.
And that's why it is said, my Lord, that is not an absolute rule. my lord, the general phraseology which is used, my lord, in cancellation of bail application is that grant of bail is a rule.
Cancellation of bail even by a higher court. While considering an application for cancellation of bail even by a higher court, these are the considerations which are to be kept in mind.
Yes. Then kindly see, my
Not
lord,
by
I
the
will not
same
address
court.
much more, my lord.
Yes.
17, 18 and 19.
Yes.
19, I will be reading, my lord. In our opinion, there is no absolute rule that once bail is granted to the accused, then it can only be cancelled if there is likelihood of misuse of the bail. That factor, though no doubt important, is not the only factor.
Yes.
There are several other factors also which may be seen while deciding to cancel the bail. And relying on these two judgments, my lord, may I come to only short facts, my lord. Admittedly, my lord, the case in the post-trial memorandum was that this opposite party in the present case, my lord, has accepted the bribe, handed it over to Pappu Srivastava, and that's why, my lord, submissions was made in the case of Pappu Srivastava that he is not the authority, rather he is a daily wager, and Mr. Srivastava, yes, Sanjay Srivastava has transferred the money to him. Yes. That led to grant of bail.
You are right. In both the cases, bail was granted by the trial court and it was cancelled by the High Court. Against the judgment of the High Court, the matter had gone to Supreme Court. Then the Supreme Court made these observations that yes, that is not the only ground for cancellation of bail. There can be circumstances where bail can be cancelled other than failure on the part of the party to appear.
No.
But by the same court, this will amount to review of an order, which is impermissible.
Which is impermissible. Of course, my lord. What I want to communicate to your lordship is this, that now that rule of exception, my lord, has been diluted by the Honorable Supreme Court. That even on merit.
A review is there.
Yes.
A review you cannot. If something.
Under the criminal law, my lord, under the once your lordship signs the judgment, my lord, functus officio is the word used.
Right.
Okay, it is all right. Now what I want to communicate, my lord, that Pappu Srivastava, when the Pappu Srivastava case was being argued, a stand was taken that he has not taken money. Sanjay Srivastava taken money, he transferred to Pappu, and that led to grant of bail. When Sanjay Srivastava approached this court, my lord, that nothing has been recovered from me.
Finally, both of them may be convicted.
Oblige lordship, these are submissions.
The State of Bihar through Vigilance Investigation Bureau has filed the present application under section 439 bracketed. Please take your seat, Mr.
All right.
439 bracketed 2 of the CRPC, seeking cancellation of bail granted to the sole opposite party by an order dated 3/6/2020 passed in criminal miscellaneous number 9292 of 2020 by this court. Full stop. The case of the prosecution, as noted in the order dated 3/6/2020, portrays that on the basis of a complaint lodged by the complainant before the Superintendent of Police cum officer in charge, Nigrani Police Station, Patna, that to the effect that the petitioner was demanding illegal gratification for registration of a will which the complainant contemplated to execute. Full stop. The petitioner was admittedly working on contractual basis as computer operator in the registration office Gopalganj, who is said to have demanded a sum of rupees 15,000 for getting the said work done. So stop. A raiding team of the Vigilance Investigation Bureau was subsequently constituted upon verification of the allegation made by the complainant. First off, this court noted from the post-trap memorandum that the petitioner and one Pappu Srivastava, a co-accused, was apprehended by the vigilance sleuths, red-handed. Full stop. Considering the submission advanced on behalf of the petitioner, bracketed opposite party herein, bracket closed, that no money was recovered from the petitioner's possession, and during the trap the amount was recovered from co-accused Pappu Srivastava, this court had allowed the petitioner a privilege of a regular bail considering his incarceration since 13/2/2020. Next, Mr. Anjani Kumar, learned senior counsel appearing on behalf of the petitioner, has submitted that said Pappu Srivastava has been allowed regular bail by this court by an order dated 19/8/2020 passed in criminal miscellaneous number 20974 of 2020, wherein co-accused Pappu Srivastava shifted the blame to the opposite party of this case. Oh, stop. He has submitted that co-accused Pappu Kumar Srivastava was granted bail on considering the submission that opposite party number 2 had handed over the amount to said Pappu Srivastava, from whose possession the amount in question was recovered. So stop. He has submitted that considering the gravity of the offence and the fact that opposite party number 2 had played the main role leading to the occurrence, he does not deserve privilege of he did not deserve privilege of regular bail, and in such circumstance his bail granted by this court deserves to be cancelled. Full stop. He has relied on Supreme Court's decisions in case of Dinesh MN bracketed SP versus State of Gujarat, reported in 2008 volume 5 SCC 66 and 2011 volume 6 SCC 189. Full stop. He has submitted that it is though true that consideration for cancellation of bail are different from consideration of grant of bail, however, the said proposition is not an absolute rule and will depend on the facts and circumstances of the case. Full stop. He has submitted that considering direct allegation against the petitioner of having accepted bribe money, the bail granted to him deserves to be cancelled. Stop. Next. In my opinion, the said decisions of this court in case of Prakash Kadam in case of Dinesh MN bracketed SP bracketed Supra and Prakash Kadam bracketed Supra have no application in the present case for the reason that the bail granted, for the reason that in those cases the bail granted by the trial court was cancelled by the High Court. Full stop. High Court, a superior court. Full stop. In a challenge to the decisions of the High Court, the Supreme Court observed in case of Prakash Kadam versus Prakash Kadam bracketed Supra in paragraphs in case of Dinesh MN Supra in paragraphs (17) as under. First off, the Supreme Court further in case of Dinesh MN bracketed SP further observed in paragraph 19 as under. So stop. Next. Which paragraph you are referring to? 2008 volume 5? 23.
23 and 25.
In case of Dinesh MN, the Supreme Court further observed in paragraph 23 as under. No, stop. Mr. Anjani Kumar Lund, Senior Counsel, has placed heavy reliance on the observations made by the Supreme Court in paragraphs 24 and 25 in case of Dinesh Aman, which read thus. Oh, stop. Next. This court cannot test the correctness of the order whereby the opposite party number 2 was granted bail in an application seeking cancellation of bail, as that will amount to reviewing an order passed by this court in a criminal jurisdiction which is impermissible. Full stop. In my opinion, no case is made out for exercise of power under section 439 bracketed 2 of this CRPC. This application is accordingly rejected. Yes.
Obliged. Milord, we are glad to note, Milord, that this is the first court, Milord, where, Milord, the recordings are made. And I have seen, I had the occasion to see, Milord, on YouTube. No? YouTube.
Yes. So
previous
all
recording.
of us, there are two aspects. Both sides should be prepared and ready and
to remain within their limitations.
And remain within limitations and respectful to each other as we have always been. Yes.
Obliged.
Item number 9. Criminal Miscellaneous 43525 of 21, Nand Kishore Pandit versus the State of Bihar. For the petitioner, Mr. Amrit. For the other side, Mr. Bhanu Pratap Singh, Mr. Manoj Kumar.
Yes.
May I please, my lords? My lords, earlier rejected white order dated 20 January 2021, my lords, with liberty to petitioner, my lords. It is Annexure 1 at page 12, my lords. The operating part is, my lords.
What is the stage of the trial?
My lords, charges has been framed, my lords.
Then?
My lords, within 6 months it was not framed, my lords. But when your lordship called for a report from learned court below, thereafter, my lord, charges has been framed, my lord. On previous occasion, my lords, your lordship was pleased to call for case diary, my lords.
Case diary has come?
My lords, case diary has come, my lords.
Yes. So what is there? Let me see the order, previous order.
My lords. Page 12, my lords, Annexure 1. Heard learned counsel for the parties. This application for grant of regular bail arises out of Nanpur PS case number 66 of 2020, registered for the offences punishable under section 363.
So I had seen the case diary.
My lords.
I had already seen the case diary. I don't know what for what did I call for the case diary.
My lords, on previous occasion, your lordship was pleased to observe that I have not given the reason for rejection of this bail application, my lords.
I have not given.
My lords, your lordship was pleased to observe.
All right.
And therefore, your lordship was pleased to call for.
Then you are taking a risk. Because you need reasons now.
No, my lords.
Therefore,
my lords, your lordship was pleased to call from me.
Yes,
do you want legend order?
Right. Normally, we don't record reasons in bail orders. on the basis of what is there in the case diary, because that may adversely affect, may prejudice at times. Bail orders are only for the purpose of grant or rejection of bail. But if you want reasons to be assigned, then I'll surely see the case diary and yes, I had simply said that on enough incriminating materials.
My lords, this was all decision of your lords, your lordship. I did not, my lords, persuade to call for case diary, my lords.
No, you must have rather compelled me to call for the case diary.
No, your lordship. It was on your lordship's part, my lords, that let me see what has come, since I have not, I have given only this much. My lords, allegation is in FIR that.
Please wait.
Should I place the FIR?
No, please wait, let me see.
Okay.
What is the name of the deceased?
My lords, Ajay Kumar.
And now I can understand the reason why I did not record the facts, because it involves prestige and dignity of a family.
My lords,
Therefore, I did not record.
My lords,
normally I record, but
my lord, that is confessional statement.
Yes,
not leading to recovery, my lords.
All right.
And in FIR, my lord, some other allegation has been leveled. There's this petitioner called Nankishore Pandit.
FIR is not sacrosanct.
And the clothes and garment of deceased was found in the house of Mithilesh Kumar. Kindly come to paragraph 8 of the case diary, my lords. It was not found in the house of petitioner, my lords. Rather, I may be permitted to place paragraph 8.
Just a minute. Yes, it's a case of honor killing. Not now. What is the stage of the trial?
My lords, charges has been framed.
After framing of charge?
My lords, my lords, my instruction is that only charges has been framed, but instruction is 1 month
Yes.
old, my lords.
What is the stage?
My lord, one date was there, but on that day presiding officer was not present, though the witness were gone for their deposition.
No, but there is nothing except the confessional statement.
My lord, recovery of the in para 22, my lord, blood has been found on the roof of the house of the petitioner, and the bamboo stick was also found there, my lord.
Where is that? Para 22?
Para 22. May I permitted to read, my lord?
Just a minute. Yes.
अभियुक्त नंदकिशोर पंडित प्रोफेसर सुरेंद्र पंडित साकिन बरमतौल थाना नानपुर जिला सीतामढ़ी के घर का निरीक्षण किया। इनके छत के ऊपर खून का धब्बा गिरा हुआ मिला, जहां तहां तथा छत पर एक सूखा बांस भी मिला, जिसे विधिवत जब्ती सूचित।
All right.
No forensic examination of my lords the blood stain.
Petitioner's prayer for regular bail was earlier rejected by an order of this court dated 21/2021, passed in criminal miscellaneous number 33197 of 2020, with an observation that the petitioner shall be at liberty to renew his prayer for bail after 6 months if in the meanwhile charge was not framed. Stop. The petitioner has filed this application renewing his prayer for bail. Stop. This is admitted that charge has been framed. Stop. Learned counsel for the petitioner has argued that there has been no progress at the trial further. Stop.
My lord, in the meantime, after getting the liberty, my lord, the petitioner had filed a discharge petition before the court will, and after the rejection of the discharge petition, the charges has been framed. So the petitioner has tried to delay the certified orders.
Filing discharge petition is no attempt to delay the trial. Everyone has a right to apply for discharge.
Yes, yes.
If according to him there was no material against him to proceed, he was right. There is nothing wrong about it.
That's why the charges were not framed within time.
Right. So what is wrong about him filing the discharge petition? There is a provision under the CRPC. He made an application. The application remained pending, therefore charges were not framed. After rejection of his application, now charge has been framed. Charge has been. What about witnesses? Witnesses have had witnesses.
Witnesses are ready to depose, my lord.
So, next. Considering the gravity of the offence and perusal of the case diary, which suggests availability of incrimination, according that,
My lords,
I am not inclined to grant the petitioner privilege of regular bail for the present. Stop. Learned counsel for the informant states that the witnesses are ready to depose before at the trial. Stop. Next. While dismissing this application, it is observed that the court below shall take all possible steps to expedite conclusion of the trial and shall not grant unnecessary adjournments. So stop. You may apply for bail anytime. I am not making any observation.
Well, some time may be indicated, then
After if there is no substantial progress at the trial, the petitioner shall be at liberty to renew his prayer for bail. Yes. Full.
10. Criminal misdemeanor 67651 after 21 November 2003 versus Akbari Khatun for the petitioner Mr. Amir Alam.
May please, my lord. This is restoration petition, my lord.
Yes. Have you removed the defects? Whether the defects?
Yes, my lord. I have removed the defect already.
Why are you pursuing this matter? You have filed this application 5 years after dismissal.
No, yes, my lord. My lord, your lordship was pleased to order number 8, my lord. May kindly be said. The order number 8, my lord.
Order number 8?
Yes.
Order number 8 of what?
Of revision number, my lord. Revision number 441/2016, my lord. My lord was pleased to grant 4 weeks preemptive time, my lord. I have removed the defect within the preemptive time, my lord. I have removed the defect on 9/12/2016, my lord. After the inspection the file, my lord, I have already removed the defect. But my humble submission regarding this case, my lord, if any defect will remain, at that time, my lord, defect was 14 clause 1 and 14 clause 2 was at that time the report which was pointed out by the stamp reporting, my lord.
What is 14.1?
Sorry, my lord, my lord, my humble submission, further give me 4 weeks time. I have removed. If any defect is found, I will be removed again, my lord.
And what is this petition about?
Petition, my lord, this revision petition against the order of maintenance, my lord. Petitioner is the husband.
Someone is appearing for the other side?
Yes, my lord. Earlier, my lord, my learned friend he appeared, but today
no one is appearing for the other side.
Today, my lord, there is not any.
Name is appearing. He has filed Wakalatnama.
Yes, sir. File Wakalatnama earlier he was already appeared before this court.
Restoration.
Yes. नहीं restoration में नहीं यूजर इससे पहले
restoration you serve a copy on him. Let learned counsel for the petitioner serve a copy of this restoration application on learned counsel who was representing the opposite party in criminal division number. What is the number?
441/2008. 441 of 2016, my lord.
441 of 2016.
16.
Stop. 16 by Friday. Serve a copy by Friday.
Oblige yours.
Stop. Place this case on Wednesday next. Yes.
Oblige yours.
11. Criminal misdemeanor 68085 of 21 Golden Singh versus the State of Bihar for the petitioner Mr. Bhaskar Shankar, for the other side Mr. Sanjay Kumar.
May I please, my lords, application for regular bail, my lords, earlier rejected by the annexure 1, page 9, my lords.
Page 9.
Lordship. This is a case under section 394, 302, 396 and 27 of the Arms Act, my lords. And my lords, in this case, FIR was lodged against 3 unknown, and only case against this petitioner is, my lord, that his name transpired in a confessional statement of co-accused Sanjeev Kumar.
So why should you be allowed bail?
My lord, up till now the case has not been dealt to Sessions Court, my lord. It is still before the London magistrate, my lord.
Call for status.
12. MJC number 3798 of 14, Muhammad Hadisham Ali Khan.
Who is for the petitioner? No, there is no representation on behalf of the petitioner. List this case on next Wednesday. No stop. The court will consider passing appropriate orders on the basis of materials on record on next Wednesday if there is no representation on behalf of the petitioner even on that day.
13. MJC number 1322 of 15, Muhammad Nasimuddin versus the State of Bihar for the petitioner Mr. Arif Raja. For the
In this case, my lord, I have filed so called on behalf of them. Yesterday I have filed with service of copy, soft copy, and if your lordship permit,
It is
then I
stated
can
by-
supply the hard copy also. Hard copy मेरे पास है अगर कहा जाएगा.
It is stated by learned counsel representing the respondent bank that a so-called reply has been filed yesterday. After service, a copy on learned counsel for the petitioner.
My lord.
You have received?
I have not received a copy.
आपके केस में ऑलरेडी पहले से फाइल है, इनके केस में नसीमुद्दीन में फाइल है. In fact, man, I have given a copy to your court master also. Your court masters also.
Court master cannot do.
हाँ ठीक है.
List this case on next Wednesday.
My lord, both
You are for whom?
Petitioner, my lord.
You?
My lord, but there are two cases tagged in
Two
this.
cases tagged, my lord,
Both of you have received counter affidavits.
I received my today.
Hard copy here I have given.
It is
Yesterday itself, soft copy was given.
This is a case, my lord, where after 7.5 years, the order is not complied till date.
There may be valid reason. If there are two things, if someone decides not to comply with the order, court is there to see what to do. The court will do. If they refuse to comply, they must be ready to face consequences also. Or there may be valid reason for not complying.
My lord.
See that.
Next Wednesday.
Next Wednesday.
Or after reopening.
All right. See, all right. 2 weeks.
My
lord.
After reopening kar.
14.
My lord. I have filed rejoinder to the show cause petition on 13/12. My only prayer is, my lord, that this case may kindly be heard along with MJC number 816 of 2017, MJC number 817 of 2017, MJC number 886 of 2017, or all analogous matter and arising from the same order, my lord.
Milord, my prayer on behalf of the opposite party number 2 is, Milord, that these
Please
two...
come this side.
Milord, yes, Milord.
You are standing, you please come this side.
I'm sorry, Milord. For opposite party number 2, Milord. So these all the cases may be placed, Milord, after 2 weeks, Milord, because I have to receive, Milord, I have to obtain some instruction, Milord, in light of the Milord, statements made in the rejoinder to the so cause, Milord.
Your rejoinder to the so cause,
my lord, which has been served, my lord, day before yesterday.
Where is the operative person of the order?
Operative person of order.
My lord. The dismissal order was quashed, my lord, with direction to pay all the back wages within 6 months, my lord. Thereafter, on plea that LPA is pending, the opposite parties refused to comply with the order, my lord. The LPA was dismissed, my lord. Thereafter, they paid rupees 4,85,000 to this petitioner, my lord. Without depriving the benefits of fifth pay revision and sixth pay revision, my lord. This petitioner represented that petitioner no, was there any direction for benefit all of the back wages means the benefits attached to the salary petitioner is entitled. That is my only submission. In contempt jurisdiction, this court will not go into that. The court no, will just see no benefit. The payment which was being made in the year 1997 was paid in the year 2012 also. Right, you have express cause of action for that. According to you, you are entitled for 10 rupees. According to them, you are entitled for 4. They have paid 4. There was no direction for payment of 10. The direction was payment of back wages.
My only submission that the benefits attached to the back wages, and they have
contempt jurisdiction, Mr.
I
Counsel.
have Annex B is my the letter issued by this executive opposite party number 2 executive officer that after order of the Honorable High Court, the benefits will be paid to these petitioners. Although my writ application is not pending, my content application is pending. That I have annexed. Annex B is the letter issued by executive officer, my lord, opposite party number 2.
A jurisdiction of contempt proceeding cannot be widened. The contempt proceeding is only for the.
I have given the all the.
Start from here. You can instead of wasting time in contempt proceeding, you should take further steps. Why should you waste time here?
Some may key direction because all are arising from the same.
All right, you give the other cases will also be listed.
I have given
for the present I am disposing of this application. It appears that this court's order, violation of which has been complained of in the present proceeding, has been substantially complied with. Stop. Learned counsel for the petitioner has, however, submitted that the petitioner has not been given the benefit of benefit of pay revision commission recommendations. First off, the court cannot widen the scope of contempt jurisdiction for entertaining the aforesaid grievance of the petitioner in relation to less payment of wages then he was entitled to, first off, he shall be at liberty to take appropriate step or approach appropriate forum for redressal of the said grievance. This application stands disposed of accordingly. These two matters are listed today.
My lord, all are arising from the same order, my lord.
No, no, listed or not?
No, not listed.
All right, let them be listed. Same order will be there. देख लेना list. Consolidated list में होगा तो list करा दो. Yes.
15. MJC number 3232 of 17. Mangal Bhagat versus the state of Bihar. For the petitioner, Mr. Nachiketa Jha. For the state, Mr. Ajay.
My lord, the counter of so cause has been filed by the state, my lord. My lord, wherein he has stated.
Now, what was the direction?
Direction is, my lord, may kindly see the page.
Page 10, your lordship.
10. Content application.
Which direction has not
11,
been complied with?
11, my lord. My lord, may kindly see page 11.
Yes.
Starts from 10. Last two lines. The district magistrate Muzaffarpur is directed to ensure that the amount of earned leave and group insurance
whether paid or not
are paid. Group insurance, my lord, I have given the rejoinder to the so cause, my lord. I have filed this rejoinder on 29/6/2019, my lord.
Yes, it is there.
Till that was not paid, my lord.
Now it is
Gratuity
paid.
was not paid. And thereafter,
Now whether this has been paid or not.
Today, direction has given me to that has been paid, my lord. But the
Just a minute.
the petitioner is no more, my lord.
All right.
My lord, next order is at page 11 itself, my lord.
Yes. Roman 2.
As regards Roman 2, as regards payment of pension, provisional pension during the pendency of the proceeding under Rule 43B of the Bihar Pension Rules, and District Magistrate Muzaffarpur shall ensure that the petitioner starts getting the same amount forthwith. The petitioner shall, for the said purpose, appear before the District Magistrate Muzaffarpur along with the copy of the order on 25/8/2017. If any paper are required to be submitted by the petitioner shall be informed by the District Magistrate Muzaffarpur accordingly to ensure that the petitioner starts getting 75% of the pension amount. That has not been. Thereafter, I submitted the papers on 25/8/2017. He has admitted in the so cause, my lord. Thereafter, that has not been paid, and he has punished me on 25/8.
25/8/2017.
That order was not complied, and he has passed the punishment order on 25/8/2017.
And when was this order passed? Order of this court?
Order of this court was passed on, my lord, 19/8/2017.
The order has been complied with then.
My lord, pension has not been paid, my lord. The petitioner has died, my lord. Today is उसका आज द्वादशा है हुजूर, और इन्होंने एक भी कंप्लाइंट नहीं किया, और जो चार्ज लगाते हैं वो चार्ज है कि एक ट्यूबवेल का कोई उसमें
The court cannot go into that.
No, my lord. I'm not going to that.
Yes, I know you are.
75% जो ये इन्होंने पेंशन देने की बात हुजूर ने कहा था, उसमें ₹1 भी नहीं मिला उस लेडी को. अब तो लेडी हो गई, चूंकि वो तो अपने चले गए, उनकी विडो हैं, उनको ₹1 भी नहीं मिला आज तक.
What was the punishment?
पनिशमेंट है हुजूर, इसी में काउंटर में ही ये सोकॉज में दिए हैं. ये सोकॉज में हुजूर उनका है, पनिशमेंट दिए हैं. हाँ, उसमें ये विथहोल्ड कर लिया इनका 100% पेंशन.
So if your pension was withheld, then you are not entitled to family pension even.
That has been deliberately withheld.
Yes, so you could have challenged that. You could have challenged that order.
That order has been challenged, my lord, at that stage, my lord. My lord, deliberately, he has not shown कि कितना अमाउंट का गमन किया, 2 ट्यूबवेल नहीं, उसका कोई अमाउंट नहीं खोले हैं, और ये डेलिबरेटली हमको 3 दिन पहले रिटायरमेंट के 1 सप्ताह पहले प्रोसीडिंग शुरू किए हैं और हमको कंटेम्प्ट किए.
Try to understand the jurisdiction of this court. The court does not.
Your intention of the district magistrate is not clear.
Maybe intention of the district magistrate, if not clear, then he can commit crime. For that, FIR can be registered. If his intention is otherwise not clear, any other action can be taken. But whether contempt jurisdiction, an action can be taken or not is the question.
My lord, he has issued 4,34,480 on the same day, my lord. He may issue the pension amount also.
He has decided not to pay you.
Your Lordship, only one thing, Your Lordship.
Perusal of the materials on record, the court is satisfied that this court's order, violation of which is being alleged, has been substantially complied with. First off, Learned Counsel for the petitioner informs that the petitioner is no more and has recently died. First off. Next, be that as it may, this contempt application stands disposed of with an observation that the petitioner's successors in interest shall be at liberty to seek a remedy before appropriate forum if according to him oblique her oblique them any grievance in relation to post-retirement dues is yet to be redressed.
Madam. Right.
MJC number 3548 of 17, Chandrasekhar Chaudhary and others versus the Bhula Mishra and others. For the petitioner, Mr. Sameer Ranjan.
May appeal, Lordship. The present MJC has been filed for restoring the second appeal, which has been dismissed for default, while order dated 13/11/17, Lordship.
Restored. I do. This matter is pending for 4 years.
Lordship.
So you should have mentioned. Notices are issued in the second appeal.
No notices were issued. No one appeared, Lordship.
70, CWJC number 3846 of 17, Mr. Shyamanand Azad and others versus the state of Bihar, along with analogous cases. For the petition, Mr. Pramod Kumar Singh. For the state, Mr. Subhash Chandra Mishra in the first case. In the second case, Mr. Kameshwar Kumar, DC 17.
Lords, may I please, Lords? First, only for the correction in the order, Lords. Order dated 1/10/2021, Lords. In fact, in the party position, the writ petition name of the writ petition number 90, Lords, is not there, Lords.
89 is also not there.
89 has been, Lords, by filing IA application, name of the 89 has been withdrawn. Now, name of the, Lords, I am sorry, name of the 91, Lords. Serial number 91, Rajendra Sharma. That is not in the Lords. In fact,
88 is Abhay Kumar Singh.
Lords, that has been withdrawn, but it is still there in the Lords.
Where is the IA or your IA? Then the whole cause list will have to be seen.
Lords, in fact, the seriatim from serial number 85, Lords, that has been wrongly typed. In fact, one person has been missing, 85 number, Lords, and therefore the entire seriatim from 85 has been, Lords, just changed.
After 85?
Lords, name of the 85 is not there in the order sheet. Dr. Ravindra Kumar. And that is why the Milords, after 85 Milords, all the
85, see what have you done? 85 was there.
Milords, serial number 85 in the writ petition
And
is
85 you have just put the whitener.
Oh.
And 85, it is because of you. 85 is Ravi Shankar Prasad. All right, up to 85 it is correct.
No, Milords, 85 is Dr. Ravinder Kumar in my writ petition. 85 Milords in writ petition, Dr. Ravinder Kumar.
No, that has been, whitener has been put on that. And 85, this is, you have done it. 85 is Ravi Shankar Prasad. You just go through the order sheet and your writ petition. And then, as requested on behalf of the petitioner, list this case on next Wednesday. So please go through the writ petition and the order sheet.
18. Adjudication number 528 of 18, Subhas Yadav versus the State of Bihar through the R.K. Mahajan, Principal Secretary, Education Department of the Government, for the petitioner Mr. Divakar Yadav. For the other side, Mr. Ritesh Kumar.
My lords, order has been complied. Only the typed copy was required, my lord. That is here.
Yes.
My lord.
It is.
My lord. Result has been not published, my lord. Result has been not published by the regulation 9B, and I does not follow, my lord, how this candidate violate the. Kindly see the, my lord, regulation 9B, my lord. I could not understand that type copy submitted, my friend, my lord.
Where is that?
So cause in so cause of.
Where is regulation 9?
Type copy.
In the so cause it has been annexed. My lords can find that in the. My lords can read in the. It is on the 6th page, my lords. Last.
Regulation 9.
Yes, my lords. Regulation 9 and then 9B is there.
9B.
My lords.
No, but I have not understood. What do you want to say?
My lord, kindly, my lord, permitted to read this rule, my lord.
Which rule?
9B.
9
B.
small b. Read it.
A candidate having completed the course failed to appear at the examination and fails to pass the examination or does not clear any paper shall be allowed to appear at the subsequent examination is only that those parts and which she failed or absented him herself on payment of prescribed examination fee without being required got 3 the course again. However, the opportunity shall be given to the examination within a period of not exceed 3 years.
Opportunity shall be given in only 2 more examinations within a period not exceeding 3 years.
In that opportunity, he has clear, he has clear, my lord. In that opportunity, he has clear all the semester, my lord.
So, what was the order?
Order was the, my lord.
My lord, order was to pass a regent order, my lord.
Passed a regent order, my lord.
So, have they allowed or rejected?
It has been rejected, my lord, since
the
first page, my lords will find.
Then you can challenge that.
Yes, well, kindly give. Yes, my lord, kindly give the
liberty.
Look
into the grievance. So you can challenge.
But kindly give the liberty, my lord.
That liberty you have. It appears that this court's order dated 22/12/2017 passed in CWJC number 18052 of 2017, violation of which is being alleged in the present contempt application, has been complied with in as much as the petitioner's grievance has been examined by the respondents, but his claim has been rejected. Stop. Next. Learned counsel appearing on behalf of the petitioner in such circumstance seeks permission to withdraw this application with a liberty to question the legality of a rejection of the petitioner's claim for publication of his result. Stop. This application stands disposed of with the liberty as sought for.
19. NJC number 579 of 18. Kanhaiya Lal Bari and another versus the State of Bihar to the District Magistrate Collector. For the petitioner, Mr. Arun Kumar Singh. For the State, Mr. P.K. Verma, AAC.
My Lord, serial number 19 and 20 both arising out of same order, my Lord, passed by your Lordship.
Yes. What was the order?
The order is at is annexure 1, my Lord, but the relevant part of the order is at page 19. Last paragraph, 16.
19, yes. Who is for the other side?
Lord, there is none for the other side, but in these cases, the SOCOJ has been filed.
Yes.
My Lord, the relevant portion of the SOCOJ is paragraph number 6, 7 and 8. It starts from page 5 2 of the SOCOJ. 5, 6. They say, my Lord,
that the matter is pending before Supreme Court.
Yes, SLP has been filed, and since the SLP has not been taken up, therefore
SLP against this order.
Against the order of the LPA court.
LPA court is SLP is pending.
Yes.
Is there any interim order passed?
No, no order has been passed.
Who is appearing for the other side? Who appears?
AC2 AAG 3rd. The notice is AAG.
There is no representation on behalf of the state of Bihar. Stop. The court will consider passing appropriate orders on next Wednesday for initiation of contempt proceeding against the contemners if the court finds no representation on behalf of the opposite parties on the next date.
Item number 20, NJC number 878 of 18, Asa Udha versus the State of Bihar.
Both are against this same order, my Lord, passed by your Lordship.
Which number?
NJC number 878 of 18.
Yes, both the cases same order. Yes, next.
Item number 21, MJC number 21. MJC number 2145 of 18, Reena Anand versus the State of Bihar through the R.K. Mahajan, the Principal Secretary Education Department. For the petitioner, Mr. Abhishek Kumar, Mr. Ajit Kumar. For the State, Mr. Shyam Satyam Shivam Sundram.
My Lord, in this matter, my Lord, Mr. Abhishek Kumar has to argue, and last week he got married, my Lord, so kindly.
Wait, let just
Lordship, the last occasion matter was adjourned to verify the latest position. As per the direction of this honorable court, if your Lordship permit me, I may place the operative part of the order.
No, whether according to you the order has been implemented or not?
Not. Your Lordship, may I place the operative part of the order?
No, why?
Because of non-cooperation of the petitioner.
All right.
Because as per the direction of this honorable court.
Place the order.
Considering the nature of relief sought for in the present writ application, it is being disposed of with a direction to the board to consider the petitioner's request, and if the board is satisfied that father's name of the petitioner has been incorrectly entered, the board shall do the needful by making necessary corrections in the concerned documents. Writ application was disposed of. Lordship, in compliance of this order, to board to
Let it come on next Wednesday because he is in difficulty. The petitioner is in difficulty.
And simply I have asked that give some proof which show that this is your father's name, because board has
All right.
experience of fraud, such type of fraud.
You can reject. You could have rejected. The board can say, the board could have said that no, your claim is not genuine, your claim is
Still,
rejected.
I have remain open for the petitioner if he is able to convince. Instead of rejecting
All right.
this,
All right. As requested on behalf of the petitioner, list this case on Wednesday.
Much obliged. Much obliged.
22, MJC number 2249 of 18, Hiralal Bhagat and others versus the Ram Sarup Bhagat and others. For the petitioner, Mr. Arun Kumar. For the other side, Mr. Dhirendra Kumar.
Lord, this is a restoration matter.
Yes. Restoration.
Yes, my Lord.
Just a minute.
The appeal by order 6/11/17, my lords are directed to take fresh steps against this number 5, 6 and 17. But that could not be done, my lord. And further, my lord, so far as 4 is concerned, my lord has directed for taking steps for substitution of heirs of this 4. But that cannot be complied with, and therefore, my lord, by order 10/5/18, the entire appeal has been dismissed for non-compliance of the order, my lord. Therefore, we have filed substitution petition, as well as limitation petition, as well as for setting aside the abatement matter, my lord. Appeal was already admitted, my lord, and notices were also issued, my lord. Some of the respondents had already appeared.
So what is the non-compliance?
My lord.
Non-compliance is in respect of what?
What of my lord for fresh service against my lord, respond number 5, 6 and 17.
16
5 or? 5, 6 and 14.
14?
Yes, my lord. And substitution against respond number 4.
Now you have done.
So far substitution matter is concerned, my lord, that we have done, my lord, with limitation petition as well as setting aside the abatement, my lord.
Limitation?
Limitation and abatement, for setting aside the abatement, my lord, and substitution, my lord, that has been done, my lord. For so far notices are concerned, my lord, because it has been dismissed, my lord, therefore we could not take any steps, my lord.
Lord, this restoration petition is, my lord.
Considering the
Lord, this restoration
someone is appealing for the other side.
My lord. This restoration
Hurdle and counsel for
time of limitation, Lord.
the petitioner and the respondents. Stop. Considering the averments made in the application for restoration of essay number 157 of 2006, the same is allowed subject to service of subject to filing requisites for service of notices upon respondents number 5, 6 and 14.
As well as not the heirs of the proposed heirs of the respondent number 4, my lord. Because substitution
As well as proposed heirs, as well as the heirs of respondent number 4, who is said to have died during the pendency of this appeal within 2 weeks?
My lord, 1 week after my lord,
1 week
Christmas, my
after
lord.
holidays. So that's all.
Date.
Both processes. Yes.
Not 1 week after the holiday, but
Yes, yes.
10 days.
So you have to comply with that part of the
Yes, my
order.
lord, that will comply, my lord.
Restored subject to allowed.
23, MJC number 4839 of 18, Dr. Asif Raja versus the Union of India for the petitioner Mr. Arun Kumar Bhagat for the state Mr. Chaya Mishra.
Your Lordship,
Yes.
on last Wednesday, a copy of this contempt.
Who is for the petitioner?
I am.
Yes.
Your Lordship, I would require at least 3 weeks time, Your Lordship, in this case. On last Wednesday, a copy has been served on me.
No, but only 2 months time. This is of 2017.
Your Lordships, pursuant to the order, they have passed an order. They have passed in purported compliance, Your Lordships. I have asked them to review the case, Your Lordships. In my view, the order should have been
Yes,
some
sir.
other way.
As requested on behalf of the CBSC, list this matter on 3 weeks.
3 weeks after.
1 week after holidays.
Your Lordships.
That's all. That's all.
Your Lordships.
24, MJC number 5074 of 18, Jaitun Nisha versus the State of Bihar through the collector for the petitioner Mr. Anand Kishore Chaudhary.
Yes.
My lords, the order is at annexure 1 and by the order your lordships has been pleased to take an appropriate decision on the representation of the petitioner, my lords. The decision has been taken which is at annexure D, page 17 of the show cause.
There is no representation on behalf of the petitioner. Learned counsel for the state is present and draws my attention to annexure D to the so-called reply filed on behalf of opposite party number 2 to contend that a reasoned order has been passed in compliance of this court's order dated 23/1/2018, passed in CWJC number 9849 of 2015. Stop. He submits that since the order of this court has been complied with, no case is made out for initiation of a contempt proceeding. Stop. On consideration of the materials on record, I find substance in submission made on behalf of the state of Bihar. This contempt proceeding is accordingly dropped.
Item number 25.
May please lordship, in this case, may be permitted me to withdraw this case with
Counsel
liberty.
for the petitioner seeks permission to withdraw this application. This application is accordingly dismissed as withdrawn.
26, MJC number 183 of 19, Catalyst College versus the Patliputra University for the petitioner Mr. Alok Kumar Sai. For the other side, Dr. Anand Kumar and Ritesh Kumar.
Yes.
My lords, in this case, Mr. Pushkar Sahi used to appear on behalf of University, my lord. The order was complied, but by the last order, my lords, I directed the Magad University to file an affidavit disclosing the current address of the then registrar, my lords.
Order has not been complied with.
My lords, it was complied, but since there was some delays on, it is on the part of the then registrar, my lords.
Yes, whether affidavit, yes, Mr. Sai?
It was complied with long time ago. That is why petitioners have also lost interest.
What about him? Respondent number 6, opposite party number 6.
We have filed the affidavit. 31/7/2019 itself.
So what is he now? I am leaving Mr. Sahi this matter, but it is very serious.
गलती तो थोड़ा डिले हो गया था बस.
Delay nahi, seems there is no representation on behalf of the petitioner. The court's order has been complied with. Stop. This contempt proceeding is accordingly dropped.
27.
My lords, in this case, my lords, I have been asked by my colleague, my lords, who has attended the ceremony, last rituals of, my lords, his cousin, my lords, grandmother. It is restoration, if I may permit, my lords, it is restoration matter, my lords, for restoration of CWJC number 1935/2014, which has been, my lords, dismissed as not pressed 2/1/11/2017, my lords. It was under misunderstanding and confusion, my lords. It was, my lord, dismissed for not pressed, my lords. As my lords, earlier counsel, my lords, Sri Durganand Jha has submitted before this honorable court that the brief has been taken.
Then?
But, my lords, the petitioner, as my lords stated in restoration petition paragraph 6, he said he has not given to Sri Durganand Jha, he has given to some other counsel, my lords. So, my lord, there was misunderstanding in between the parties. So, it
He had given to whom?
given to, my lords, one Rajesh Mohan.
File.
My lords, he has given his file to Rajesh Mohan. As I have read, my lords, in restoration petition. If possible, my lords, it may be restored.
Restore, I intend to initiate proceeding against the petitioner.
Then, my lords, I may
This
pray.
is a very serious kind of allegation being made against a counsel of this court.
May I humbly submit, my lords, it may be possible because I have been asked
Yes,
by
I
my...
will pass it over.
My lords,
This I cannot tolerate.
my lords. Oblige.
28. MJC number 1758 of 29/19. Sanjeev Kumar, alias Sanjeev Kumar Singh versus the State of Bihar for the petitioner Mr. Surya Narayan Roy.
Restoration application, your lordship. Preemptory order was not complied with. And thereafter, with regard to court fee, your lordship, because there are so many petitioners in this case, on one court fee petition was filed.
CWJC number 3812 of 2019 is stood dismissed for default for non-compliance of preemptory order of this court dated 26/2/2019. Full stop. This application has been filed for a restoration of the said writ application. Stop. By what time will you comply with?
I have complied, your lords.
all defects, all directions.
कोर्ट फी दे दिया गया,
बाकी
बाकी टाइम दे दिया जाएगा.
Considering the averments made in the restoration application, which indicate bona fide of these petitioners, comma, the same is allowed subject to full compliance of the preemptory order dated said preemptory order dated 26/2/2019 passed in CWJC number 3812 of 2019 within by 1 week after holidays.
Item number 29, MJC number 618 of 20, Shankar Prasad Singh versus the State of Bihar. For the petitioner, Mr. Naveen Prasad Singh. For the State, Mr. Mohammad Khurshid Alam, AG12.
My Lord, I may be pardoned, my Lord. In the order dated 5/8/2019 for taking fresh steps, for taking fresh notice, my Lord, that could not be complied with, my Lord, because of that, my Lord, in a substitution petition. And for non-compliance of that, my Lord,
So what do you want?
time, my Lord, the entire writ application has been dismissed.
What do you want?
My Lord, I want the restoration of the
restoration. All right. How much time will you take to take steps for?
My Lord, I have already submitted. I have already filed, my Lord, on 5th February 2020, my Lord.
All right. The learned counsel for the petitioner states that the preemptory order dated 5/8/2018 passed in CWJC number 897 of 1991 have since been complied with. So stop. Considering the aforesaid submission and the averments made in the restoration application, the same is allowed. Let so and so be restored to its original file. Yes, next.
Item number 30, CWJC number 8023 of 20, Amit Kumar Singh versus the Union of India. For the petitioner, Mr. Rajendra Prasad Shah, Mr. Kumar Kaushik, Michael Stewart. For the Union of India, Dr. K.N.C.
Yes.
My Lord. A brief written notes of arguments.
Yes.
My Lord, the issue in the present case is whether a candidate who has completed his graduation by way of an entrance test conducted after the completion of bachelor preparatory program instead of a formal 10+2 education shall be eligible for participating in selection processes where the graduation is the basic qualification, albeit the candidate concerned does not have a formal +2 degree. Now, my Lord, as I could figure out, there are two basic issues. The firstly is whether the degree of graduation is recognized, and secondly, if it is recognized, whether the recruitment bodies have any jurisdiction or authority to not consider that degree as eligible in such recruitments. Now, insofar as the first question is concerned, the regulation of 1985 with respect to open school, which my Lord will find.
Where is that?
My Lord, in the compilation, it is at page number 68. There is one index which I may provide because the compilation does not have any index. At page 68.
Yes. Yes.
UGC Regulations 1985 regarding the minimum standards of instructions for the grant of first degree through non-formal distance education. The relevant provision is Regulation 2. No student shall be eligible for admission to the first degree course through non-formal distance education unless he has successfully completed 12 years schooling through an examination conducted by a board university. In case there is no previous academic record, he shall be eligible for admission if he has passed an entrance test conducted by the university, provided that he is not below the age of 21 years on July 1 of the year of admission. Now, this, my lord, prescribes that
This is exception to the first condition. Second sentence is an exception to the first condition.
My lord. Second is, no student shall be eligible for the award of the first degree unless he has successfully completed a 3 years course, which is that even if formal schooling is not there, even then he can be admitted to graduation, but graduation degree will be awarded only after a 3-year graduation course has been completed. This degree may be called BA, BSc, BCom, General Honours, Special Degree, as the case may be. And then it is stated, provided that no student shall be eligible to seek admission to the master's course in these faculties who has not successfully pursued the first degree course of 3 years duration, which is that for master's course 3 years course is mandatory. But there is a further exception provided further that as a transitory measure where the universities are unable to change over to a 3-year degree course, they may award a BA, BSc, BCom pass degree on successful completion of 2 years course, but that no student of this stream shall be eligible for admission to master's course unless he has undergone a further 1-year bridge course and passed the same. The 3-year degree course after 10+2 stage should in no case be termed as BA, BSc, BCom pass degree, which is, my lord, as I could understand, the BA, BSc, BCom pass degree is a degree which is awarded after 2 years graduation, and then if the candidate undergoes a further 1-year bridge course, he can be admitted to the master's degree. And the regular 3 years course was prescribed in Regulation 2.1. Now, as per this regulation, even if a candidate does not have formal 10+2 education, he could still be admitted to graduation and he could still be awarded a valid graduation degree. Now, the writ petitioner in the present case has also not cleared the 10+2 formal education, and he has passed the entrance examination conducted by the IGNOU. After this 1985, this, my lord, was issued in exercise of powers conferred by clause F of subsection 1 of section 26 of the UGC Act. Now this subsection gives
Clause F of subsection 1 of
section 26 of the UGC Act. This, my lord, section 26 clause 1 subclause F prescribes the Commission may by notification in the official gazette make regulation consistent with this act and rules made thereunder. Subclause F prescribes defining the minimum standards of instruction for the grant of any degree by any university. Now this, my lord, was repealed in the year 2017 when in suppression of 1985 regulation, 2017 regulation had come into force, which is at page number 72.
After 32 years after 1985.
32 years after 1985.
Where is that?
72. The top portion of the same reads as, in exercise of powers conferred by subsection 1 of section 26, read with clause J of section 12 of the University Grants Commission Act 1956, and in suppression of the University Grants Commission regulations, the minimum standards of instructions for the grant of first degree through non-formal distance education in the faculties of arts, humanities, fine arts, music, social science, commerce and sciences regulations 1985, except as respect of things done or omitted to be done before such suppression, the University Grants Commission makes the following regulations, namely. Now, in this regulation, my lord, there is no provision akin to the regulation 2(1) of the 1985 regulation. After this regulation,
please it again. In exercise of powers
under subsection 1 of section 26.
So there is no provision akin to this
Earlier 85 regulation, which provided that without formal 10+2 also, through an entrance examination, a candidate could have been admitted into graduation. There is no such provision in 2017 regulation. Then the 2017 regulation was also suppressed by 2020 regulation, which is page 87.
Page
87.
Yes.
In exercise of the powers conferred by subsection 1 and 2 of section 26, read with clause J of section 12 of the University Grants Commission Act 1956, and in suppression of the UGC supersession of the University Grants Commission, Open and Distance Learning Regulations 2017, and University Grants Commission Online Courses or Programs Regulation 2018, except as the respect of things done or omitted to be done before such supersession, the University Grants Commission, with the previous approval of the central government, hereby makes the following regulations, namely. Now the relevant provision of this regulation is Regulation 22, which my lord will find at.
No, but where is this? University Grant Commission Open Distance Learning Regulation 2017. This is what you are reading.
My lord, the 2017.
Page 72.
Page 72.
All right. Yes.
Now, page 110, Regulation 22 is the relevant provision. Regulation 22 provides equivalence of qualification acquired through conventional or open and distance learning and online modes, degrees at undergraduate and postgraduate level in conformity with UGC notification on specification of degrees 2014 and postgraduate diplomas awarded through open and distance learning mode and or online mode by higher educational institutions recognized by the Commission under these regulations shall be treated as equivalent to the corresponding awards of the degrees at undergraduate and postgraduate level and postgraduate diplomas offered through conventional mode. So therefore, it is only the degrees at undergraduate and postgraduate level in conformity with UGC notification on specification of degrees 2014 which was treated to be equivalent. Now the 2014 notification has been incorporated by reference in the 2020 regulations. 2014 notification, my lord, will find at page number 115. This was framed in exercise of powers conferred by subsection 3 of section 22.
Yes.
So I may read subsection 3 of section 22 of the UGC Act. It prescribes section 22 clause 3.
Yes.
Right to confer degrees. The right of conferring or granting degrees shall be exercised only by a university established or incorporated by or under a central act, a provisional act or a state act, or an institution to be university under section 3, or an institution specially empowered by an act of parliament to confer, to grant degrees. Clause 3 says, for the purposes of this section, degree means any such degree as may, with the previous approval of the central government, be specified in this behalf by the Commission by notification in the official gazette. Now this notification, my lord, was in supersession of all earlier gazette notification in this regard. The last such notification as I could find out was 2009, which I would refer to after referring to this. Now this, my lord, will find prescribes the nomenclature of degrees, and the last column is entry qualification, and against the degree of BCom, which is serial number 32, next page, entry qualification is 10 plus 2, and in fact against all the undergraduate degree, the entry qualification prescribed is 10 plus 2. Serial 18 is BA, there also entry level qualification is 10 plus 2.
Yes.
A comparison with 2009 notification, which is at page 112, would disclose that in 2009 regulation there was no entry qualification prescribed, which is prescribed in 2014, which has been incorporated by 2020 regulations, which are in supersession of 2017, which in turn was in supersession of 1985 regulation. So therefore, there is no dispute with respect to the recognition of the degree from 1985 to 2014. Now, after the 2014 notification was issued under subsection 3 of section 22, the 1985 regulation and the 2014 notification were coexisting. Now, in this regard, my submission is that both the notifications are issued in exercise of powers under different sections of the UGC Act, and any interpretation of one notification rendering the other one totally authorized, instead of that construction, a harmonious construction if possible may be adopted, wherein 1985 regulation, which was only for open and distance education, may be allowed to coexist with 2014 notification, which is for both formal and non-formal education, the specification of degree, and 85 regulation may be an exception to the degree specified in the 2014 notification, because 1985 was meant only for open and distance education. But after the introduction of 2017, the 1985 regulation ceases to exist, and it is only the things which have been already done in the year until the year 2017 can be saved. It also had a saving clause, the 2017 regulation. So therefore, it is difficult to accept, unless there are contrary notification, that after 2017 notification, the degree, graduation degree, without completing 10 plus 2 formal education would be valid as per the regulations which are on record in the present.
Then what is the purpose of granting such degree by this you call, what is the name of the university? IGNOU?
IGNOU.
What is the purpose of grant of such degree by IGNOU?
In this case, my lord, the degree was granted in the year
No,
2015.
forget the case. We are no more case specific. We are about to understand the general scope. So if the degree after 2017 granted by the IGNOU has no validity if they don't have 10+2 qualification at the time of entry, then what can be the purpose? Then the entry itself is illegal.
My lord.
The entry into the said course itself is illegal. If they are permitting, they might not be permitting, we don't know.
If they are
They
permitting,
might
my
have
lord,
stopped.
because there have been disputes with respect to the degrees, and in Annamalai University also there was a question with respect to the same, wherein the Honorable Supreme Court, after analyzing the competing statutes, UGC and the Indira Gandhi Open University Act, has held that the UGC Act and regulations issued thereunder will be binding even on the Indira Gandhi University, Open University, and since it was framed in exercise of powers under List 1, Entry 66. So if the UGC does not validly recognizes the degree, then there is no purpose in admission of the candidates to such degrees in the Indira Gandhi Open University, in my submission. If there are other notifications which are carving an exception, because I have come across one notification which was an amendment to the 2017 regulation, which provided that UGC may exempt the Indira Gandhi National University from the application of 2017 regulations by way of a notification. That, my lord, will find.
But that is only enabling provision. No decision has been taken. No.
Whether it has been taken or not is UGC
That
may
is a
answer
question.
that. I could not find anything that a decision has been taken.
Where is that?
That my lord will find at page number 86.
Yes, this we had noted on the last occasion.
My lord. A proviso has been added by way of section regulation 2, provided that the University Grants Commission may, by order, exempt the Indira Gandhi National Open University, a university established under the Indira Gandhi National Open University Act 1985, from the application of these regulations, considering the objectives of the said act.
Yes.
Now, if we come to the second question,
Yes.
that if the degree is recognized as it appears from the 1985 regulation,
At least up to 2014, maybe up to 2017.
So if the degree is valid and recognized, because the petitioner's degree is in the year 2015, and even the 2014 regulation says that those who have already enrolled, for them it may not be applicable. So for such candidates, whether the recruiting bodies are justified in insisting for a 10+2 formal education. Now in this regard, my lord, I had placed reliance on one of the decision of this honorable court, which is at page number 30. This was a case where
Yes.
Page 30, I may read the relief. The prayer of the writ petitioner has been quoted.
Yes.
For setting aside a letter contained in memo number so and so, was issued under signature of Director Secondary Education, Department of Education, Bihar, Patna, with regard to serial 2 therein, given direction to all district education officer establishment that those applicants who have passed bachelor's preparatory program in place of intermediate are not be eligible for the post of secondary teacher in teacher appointment 2012. Now, at page 34,
Yes.
my lord will find in the middle at page 34, after quoting the rule, it is observed, as would be evident, there is no indication as to how a candidate would pass out his graduation examination. He may have undergone any course at the intermediate level, but the evaluation which has to be made for the purpose of determining the merit is only to award credit point marks for different examinations beginning from the matriculation. Thus the procedure of calculation of merit position has been separately provided under Rule 6, which reads as follows. And then at page 36,
Yes.
last third line from the bottom, candidates like the petitioner who has of course got the graduation and post graduation as also the qualification of B.Ed and or M.Ed, therefore simply cannot be held ineligible only because he had not undergone the course and appeared in the examination of higher secondary intermediate. The petitioner, being a trained graduate, easily qualifies in terms of Rule 2006 for the post of teacher of secondary school and in fact also for the post of teacher of higher secondary class. Thus the clarification given by the state government in the impugned order by the Director Secondary Education, to the extent it disqualifies the candidate like the petitioner, is in teeth of the provision made in the 2006 rules. The following underlined portion of the clarification issued by the state government would by itself be sufficient to show no, that no all courses of IGNOU have been held to be invalid. It is only the graduation degree of tourism of IGNOU which has been held to be not qualified, the requirement under Rule 2006. In other words, a person who has obtained graduation qualification from IGNOU in other disciplines has not been held to be disqualified for the post of teacher. In that view of the matter, the aforesaid underlined portion of the clarification cannot be held to be correct, much less in accordance with law. This court, however, must immediately clarify that the evaluation of a candidate, including the petitioner who has undergone the BPP course of IGNOU and thereby has neither undergone nor completed the higher secondary and intermediate, will be made on the same parameter as given in the 2006 rules. In other words, if the petitioner has completed matriculation, graduation and teacher training course, the percentage of all these three examinations shall be added along with giving him 0 marks for intermediate, higher secondary examination, and his average will be taken out in the manner described under the 2006 rules by dividing it by 5. This was assailed in LPA, which is a very short order at page 42.
Yes.
Now paragraph 2 of this judgment prescribes, appeal has been preferred by the state against the order of the learned single judge, primarily on the ground that since a bridge course conducted by Indira Gandhi National Open University, known as Bachelor's Preparatory Program, not being equivalent to intermediate, the state government is facing difficulty in evaluation and award of marks to such candidates who have done BPP bridge course and then graduation.
Yes.
And then quoting the order, it was held that nothing further is required to be done and appeal was disposed of.
Right.
Then another order is at page 44 by the Honorable Madras High Court. There were two sets of writ petitioners in this case. One, those who did not complete graduation but had completed post graduation. And two, those who had not completed intermediate but had completed graduation. Now, while allowing the set of the writ petition filed by the second set of candidates who had not completed +2 but had completed graduation, the discussion is in paragraph 27 to 35 at page 64. Then comes the last category, which the persons who obtained degree through non-formal distance education mode without passing +2 examination, but they were admitted to the degree course after they passed the entrance examination conducted by the respective universities. The following petitioners comes under this category. Now paragraph 29. At this juncture, it is relevant to again reproduce the relevant portion of the clause 1 of regulation 2 of 1985 UGC regulations as hereunder. Then, my lord, it was 2.1 was quoted. Para 30 states, in view of clause 1 of regulation 2 of 1985 UGC regulations, the relevant portion of which is highlighted above, I am of the view that these petitioners are entitled to be selected for the group 2 post and they should also be given appointment. At this juncture, it is also relevant to note that this court passed an interim order of status quo on so and so in respect of 35 vacancies lying as on date in MP number so and so. I am not in agreement with the submission made by the learned Additional Advocate General for the government and the learned Senior Counsel for the TNPSC, that as per GOM number 107, the degree awarded in the non-formal distance education mode to the candidates who passed +2 examination alone shall be considered as a valid one. I am of the considered view that the validity of a degree shall not be tested on the anvil of the government order, but the same shall be tested on the relevant UGC regulations. The relevant regulation framed under Section 26 of the University Grants Commission Act 1956 is 1985 UGC regulations, and clause 1 of regulation 2 of 1985 UGC regulation makes it clear that the open universities could admit students to the degree course in the non-formal distance education mode, even if they did not pass +2 examination, but those students should have passed the entrance test for admission to the degree course. The aforesaid clause in regulation 2 shall be read into GOM number 107 PNAR department dated so and so. Therefore, I shall have no hesitation to reject the submission of the learned Additional Advocate General and the learned Senior Counsel for the TNPSC. So, if the degree is recognized, then the respective state governments or any government or the public service commissions or any recruitment body have no authority to declare the candidates ineligible. Now, whether the degree is recognized or not, my lord, these are the sets of regulations in place. As in my humble submission, 85 regulation, until the 2017 it should be recognized.
Thank you. Thank you, Mr. Patel. Yes, so who is for the IGNOU? Someone is there for IGNOU is a party. Indira Gandhi National Open University is a party. Someone is representing. Yes, UGC.
Milord, we have got instructions, Milord. In a week or so, Milord, we will be filing. It has gone there for affidavit, which will be coming, Milord. On next Wednesday, I will be able to assist you. We have got the instruction, Milord, that UGC at its own is not distinguishing whether it is by Indira Gandhi Open University or regular course, whether intermediate or not intermediate, they are not distinguishing, but it has been left open for the recruiting agencies who deem it expedient that the person for that particular post should have intermediate and regular classes, then that.
Then your UGC should be closed. If this is the stand of the UGC, that this should be left to the recruiting agencies and the state government departments to decide which degree is recognized or not, then what for the UGC is there?
UGC is recognizing. They are making no distinction. They are saying they have granted permission. Therefore, this Indira Gandhi Open University is there.
Therefore, have you noticed the submissions which have been advanced? The submission is that from 1985 to 2017 there may not be any difficulty if a candidate does not have 10+2 certificate with him, but has BA course, BA degree, BA awarded by the IGNOU, Indira Gandhi National Open University. But after 2017 the things have changed. There is some difference between 1985 regulation and 2017 regulation. There must be some reason why the UGC has made this distinction. And if there is no reason, then it's very difficult to comment upon the conduct of the UGC. If they are not sure why the distinction was made from 1985 in 2017, then the matter is different, and the court will see what the UGC is doing.
It will be there.
It is very difficult situation when the UGC is failing to assist. Please caution your commission. We are getting no assistance at all. Yes.
May I, Lord? I'm sorry, Lord.
Serial number 7, my lord.
What happened?
No one could appear, my lord. It has been, my lord, mentioned. No one appears, my lord. I was supposed to assist your lordship, my lord. My friend, my lord, was.
What has happened in that case?
No one appears, my lord. Just for that, my lord.
All right.
No one appears.
All right.
Well, it's similar is the situation in my case, my lords, item number 19 and 20. No one appears, and my lords, the persons have been asked to face charges on contempt, my lords.
Then what can be done? If you are Mr. Verma, if there is an order of this court.
No, I will.
The order has not been implemented.
It might have been already complied, my lords. Show cause is not filed, my lords. Just one chance may be given. No one appears is also
then
recorded.
Your officials are taking the court proceedings too lightly.
We could not appear, my lords. No one appears.
Because it seems that we have become rather more indulgent.
My lords,
how dare a government servant can official can think of disobeying?
My lords, for myself,
because we are liberal.
For myself, my lords, I myself take it very seriously. I do not give any chance to them. Just one chance for my office, my lords. My office was also default.
Next, all right.
Let it come, my lords, next
Wednesday.
week.
It will come on Wednesday. We will see.
My lords, oblige, my lords.
Next Wednesday.
Milord,
order huzur non-appearance ka.
All right.
Milord, in serial number 24, Milord, that said case has been disposed of by your lordship, and Milord, I was making argument in court number 30.
All right. What do you want?
हुजूर हमारा अपीयरेंस
पेटिशनर
की तरफ से एक और मेरा प्रेयर था हुजूर डिस्पोज्ड ऑफ हो गया, हम फ्रेश रीट एप्लीकेशन का एक डायरेक्शन दिया जा करेंगे.
Fresh, you have always that liberty is there always with you.
ये 17,945 that is not bad.
केस नंबर लिख दो, नाम अपीयरेंस का लिख दो. अपीयरेंस लिखो ना अपना और स्टेट